May 28, 2024. Court Smart's operated by our court clerk, Sue Hall. Our official court reporter is present. She is the official record. The Court Smart recording is not available for release. This is the matter of State versus Christopher Gregor, case 21-1881. Would counsel please put their appearances on the record?
Your Honor, Christine Lento appearing on behalf of State.
Assistant Prosecutor Jamie Schroen for the State.
Good morning, Ms. Lento. Good morning, Ms. Schroen. Good morning, Your Honor. Mario Vellucci, along with
Andrew Ferranti. Good morning.
on behalf of Mr. Gregor, who is seated between us.
Thank you, everyone. Mr. Gregor appears in court appropriately attired in a blue suit, a white shirt and tie. The jury is reporting approximately 9:30. We have some issues with respect to the jury room. The temperature is unbearable in there. I spoke to the director of operations who's dealing with the county. I guess it's a combination of shutting off the air conditioning over the weekend, which is never a good idea, plus power failures that were experienced in the area. In fact, power went out in the Justice Complex about 2:30 on Friday afternoon and resulted in the early closure of the Justice Complex, so it's probably just as well we weren't here that day. Sheriff's officers confirmed that the temperature in the Justice Complex yesterday was unbearable. So I'll tell the jury when they come in that the jury room is very warm, and if they have any issues, please let us know. We've set up 2 fans in there, but I don't anticipate the jury would be deliberating or having to spend any lengthy periods of time in there. If we do have to excuse them for any reason, we should probably send it back to jury assembly based upon that. The state filed a notice of motion to bar certain aspects of Dr. Michael Bodden's testimony. Defense counsel have responded, and their response is also fastened as a cross motion with respect to Brady material. I've considered all the submissions. I'll be happy to hear first from the state if you have anything to add about your motion, Ms. Schroen.
Your Honor, the State doesn't have anything to add about our motion. We did file a notice of motion and a short brief regarding the area. It's the State's position that we're not seeking to strike the entire testimony of the expert. We're merely trying to strike a portion of the testimony which would not be adequate for this expert to testify to. Even in terms of a layperson giving this type of opinion, testimony wouldn't be appropriate. Moreover, Judge, in terms of what the expert had relied upon and the underlying facts of the case, there's also nothing that has come into this court to even establish what the defense attorney's expert is trying to give an opinion on. So it's really twofold. Number one, that it would not be the subject of an expert opinion, and number two, the state nor the defense has called Dr. Ragasa anyway, and there's nothing in the discovery which would even form a basis of the expert's opinion to make such a finding anyway. So that's really the crux of our motion. In regard to the Brady motion, the state submits that that is not subject to Brady material in terms of who the state speaks to or doesn't speak to in regard to obtaining an expert. Moreover, Judge, this was already asked for a long time ago, going back when we were talking about the severance motion. And quite frankly, we had a discussion about it in chambers, and I advised the court and I advised counsel that we spoke to one expert, and that's it. And so this information was already proffered a while ago because we proffered it. But in terms of the actual motion and its Brady material, it's not something that the state would have to proffer, and we would submit.
Thank you. Ms. Ferranti.
Judge, I would ask the court to deny the state's motion. Frankly, it's late in the game, so to speak, for the state to make this motion. They've been on notice of Dr. Bodden's testimony. It's the same testimony or same topics that their expert testified to. So to make it in the midst of a defense case, it's just way too late. And I think it speaks to the potential interruption of a defense already partially presented. And while the defense has no obligation to present one, the fact that we've chosen to go forward with one, and now that people are making the motion, where under similar circumstances the defense would be denied from making that motion, we would have waived our objection, seems palpably unfair. In terms of the proffer, it is my position that it's Brady. Quite frankly, the state has chosen not to call Dr. Ragasa. That's their request. It should not be precluded from our expert testifying if it forms the basis of his opinion, which it very much does. I do not see how the state can take the position that it can't possibly form the basis of expert testimony. They are not the expert, nor would they be deemed such. So I do feel that the motion is out of turn to be made at this late of a stage. Dr. Bodden should be able to testify to anything within the realm of his expertise. And I did cite in my reply, Judge, that I quite frankly did not understand why the state would make the suggestion that he's not an expert on those particular areas, given the number of lectures and articles he's written on those various topics.
Thank you. The matter comes before the court on first the state's motion to bar certain testimony by Dr. Bodden. Defense counsel asserts that pursuant to Rule 3:10-3, the motion is untimely. Reliance on that rule is misplaced, as that deals with a state's expert who did not conduct the underlying studies. The genesis of that rule was the death of an original expert who did certain studies, and whether a substitute expert could testify in place of that expert, and it contains a time frame for objections by the defendant. The rule simply has no applicability to this motion by the prosecution against Dr. Bodden. Secondly, even if the rule was applicable, our case law and our court rules provide that trial judges are gatekeepers when it comes to the appropriate scope of expert testimony. Under Evidence Rule 702 and State v. Odom, O-D-O-M, 116 New Jersey 65 at page 71, a 1989 case, courts are required to make sure expert testimony relates to a relevant subject that is beyond the understanding of the average person of ordinary experience, education, and knowledge. Therefore, it's well settled that trial judges acting as gatekeepers, quote, must ensure that expert evidence is both needed and appropriate, even if no party objects to the testimony, end quote. State versus Nesbitt, N-E-S-B-I-T-T, 185 New Jersey 504 at 515, a 2006 New Jersey Supreme Court case. It's well settled that it is not appropriate or proper to present expert testimony about straightforward but disputed facts. In the Nesbitt opinion, the Supreme Court cited with approval many appellate division decisions that barred expert testimony about clear-cut matters that an average juror could understand. And that's the Nesbitt case at page 516. In addition, experts cannot opine directly about guilt or innocence, nor can they express an opinion as to the credibility of a witness or a party. That's also the Odom case, as well as State versus Vandeweghe, V-A-N-D-E-W-E-A-G-H-E, 177 New Jersey 229 at 239, a 2003 New Jersey Supreme Court case. So therefore, even in the absence of a motion by the state, the court has an independent obligation to make sure expert testimony is appropriate. The state recites certain areas of Dr. Bodden's report. On page 2, the first paragraph, last sentence, begins with the word she, referring to Corey's mother, Brianna Michelot. Quote, she had also made a number of unfounded child abuse accusations against Mr. Gregor to the state's Division of Child Protective Services and to the police, end quote. As the defense correctly points out in its response, that testimony was not elicited at all. The prior complaints regarding DCP&P investigations did not come into evidence, so that portion of it is arguably redundant, as Ms. Ferrante characterizes it. But nevertheless, Dr. Bodden has no personal knowledge whether those complaints were unfounded. The DCP&P may have concluded they're unfounded. All that's hearsay. It's not the type of medical hearsay that a doctor would rely upon. So the last sentence of the first paragraph on page 2 is inappropriate. It shouldn't be testified to by Dr. Bodden. Next, on page 5, in the first paragraph, Dr. Bodden refers to Dr. Ragusa's conclusions and his initial determination that the manner of death was undetermined. Clearly, that's part of the records of the autopsy. Dr. Bodden should be permitted to testify about that. However, the second sentence begins with the letter he, again referring to Dr. Ragusa. Quote, he rejected law enforcement requests to reconsider and change the manner of death to homicide, end quote. Law enforcement requests are not the type of medical documentation that a forensic pathologist rely upon. Law enforcement requests are opinion testimony. They're not even appropriate. If law enforcement was testifying to it, it's inappropriate, irrelevant, hearsay, and if there is some marginal relevance to it, the probative value is far exceeded by the undue prejudice, the confusion of the issues, and a waste of time under Evidence Rule 403. So the second sentence on page 5 is inappropriate, and Dr. Bodden shouldn't testify to it. The doctor then continues about his opinion concerning the acute inflammation and sepsis. Now, the second paragraph on page 5 begins with, quote, because Dr. Ragusa did not agree with the police opinion that Corey's death was a homicide, the prosecutor contacted Dr. Thomas Andrew for a second opinion, end quote. That's inappropriate expert testimony. First, the police opinion that Corey's death was a homicide is not evidential. It's hearsay. It's not a medical opinion. It's inappropriate for the jury to hear about that. The jury already knows that the state contacted Dr. Andrew. The jury already knows that Dr. Ragusa did the autopsy and that the state has not called him. There's no evidence in this trial for even the court to conclude that the police did not agree with Dr. Ragusa's opinion, or Dr. Ragusa did not agree with the police opinion. So that's inappropriate. It's not the type of hearsay relied upon by medical experts in their field. It's totally irrelevant. The remainder of the report in this court's view is appropriate. Every other reference in the report, even if there's some hearsay or the type of hearsay statements or background materials relied upon by experts in the scope of their duties. So I'm not limiting any of the medical testimony by the doctor. I'm going to mark the doctor's report as a court exhibit so defense counsel can utilize that. I do have some handwritten notes, so I'm going to mark a second copy. So defense counsel can show that to the expert. Madam Clerk, Exhibit C next in order. 16, thank you. Defense counsel also brings a Brady demand alleging that, quote, it has become readily apparent to the defense that a gap exists in the prosecution's evidentiary trail between Dr. Ragusa and Dr. Andrew, close quote. Defense then alleges, given the state's motion to limit Dr. Bodden's testimony, it's an imperative that the state affirm on the record all experts that have consulted between Dr. Ragusa and Dr. Andrew, and then ask for any documents related to those experts. Ms. Lentos just confirmed that the state only consulted Dr. Andrew, but regardless, this court's view is that under Rule 313(3) subsection D, certain materials are not subject to production. That subsection of the rule provides documents not subject to discovery. This rule does not require discovery of a party's work product consisting of internal reports, memoranda, or documents made by that party or the party's attorney or agents in connection with the investigation, defense, or prosecution of the matter. that's a quote in part in that section. If the state consulted with one or more of other experts, for a variety of reasons, those experts may not have agreed to become engaged. Maybe their fees were too expensive, maybe they couldn't reach an opinion, maybe they had scheduling difficulties and are unavailable to appear at trial, maybe they didn't want to be involved in this type of case involving the death of a child. That's not evidential. It's of no particular relevance. Parties are able to consult, lawyers are able to consult experts in order to find an expert who potentially can support that party's position. So I find that, first, the request here is in the nature of a work product, which is privileged and the state's not required to disclose it. Secondly, it seems conjecture to say it's readily apparent that a gap exists between the evidentiary trail. I'm not aware of an evidentiary trail being required between experts. The court's aware of an evidentiary trail with respect to a chain of custody, for instance, with regard to items being admitted in evidence, but I'm not aware of any requirement that there be an evidentiary trail between Dr. Agassi and Dr. Andrew. Defense counsel is obviously free to argue that Dr. Andrew was retained months after Corey's death, that he was unable to provide I shouldn't say that, not unable. He did not provide an opinion until about 1 year after the death. His report has a date on it that counsel's aware of. Obviously, defense counsel is free to argue that the medical examiner performed the autopsy, was not called by the state to testify. However, those things do not require the production by the state of any other conversations with some other expert. And it would be inappropriate to turn those over. I contrast that with a fact witness. Obviously, if the state had fact witnesses who were present at the autopsy or somehow collected evidence or conducted examinations of bodily samples, then the state would be required to produce those. But merely consulting with an expert is not, in this court's view, at least in the absence of any citation to a court rule or a case brought to my attention. I've done my own independent research, and I can't locate any obligation to do that. So the state's motion is granted in part. Defense motion is denied. Mr. Galucci, if you want to copy this report so you can go over it with Dr. Bodden, it should just take you a minute or so.
Judge, may I just add something to the record?
Sure.
After the testimony today, I would just ask that we can address what is permissible in closing, absent the fact that there's been no request under Clowens. So if we could readdress that issue with regard to Dr. Ragasa not testifying after the witnesses today.
There was no request made before the end of the state's case, so there can't be an adverse inference charge. You're required to get that before the end of the state's case.
Correct.
Thank you, Judge.
But that's with regard to a charge by the court. If the defense wants to argue that the state didn't call somebody, that you can typically make that observation.
Judge, we'd ask if we could do a little research on that.
Yeah, sure,
At
that's
the end
fine.
of the day, please. Thank you.
That's fine. Right. Mr. Galucci, do you want this report?
Judge, he's not testifying to any of that anyway, so I'm not really concerned.
All right. Well, it would have been helpful if you told me that was the case before I ruled on those issues.
I did tell you last week that all of those issues were probably going to be moved, and they are.
Why file opposition? You filed a multiple-page opposition to this.
I think that we are obligated to respond to a motion.
Well, yeah, but unfortunately, the response argues that the state's application is untimely and it should be denied in its entirety. And you just stand up now after I make this ruling and do this research. And I mean, it's okay. I'm still able to enjoy Memorial Day weekend, but I otherwise enjoyed doing that research over the weekend for something that wasn't necessary. But it's okay. I'm not the slightest bit distressed by it. I'm happy we're all here. Happy we have a witness, and we can get moving along with this matter. All right. So, can we get to see if the jurors are ready? Did Sergeant Doom go over or no?
Yes. Yes.
She did. All right, great. Thank you.
Judge, our first witness is going to be probably the Seabright witness.
Okay, very good.
Okay.
Thank you. I'm glad you were able to rearrange him too. I thought about that when we had to cancel Friday. Good morning. You're going to find You want some time? All right, please be seated. All right, it's 9:41 a.m. The jury's in the jury room.
Can the front row slide down so we make room for as many people as we can, please?
think we also have courtroom 11 is available for overflow, right?
One.
Courtroom 1?
Courtroom one. That's what Terry told me. Let me double check.
One.
One.
You can.
What's that?
You guys are just gonna have to stand. So you can sit there if you want. I'll have to go over right on and I'll go.
You guys ready? Everybody ready? Doors out.
Not yet.
Yeah.
Thank you. Everyone, please be seated. Good morning, ladies and gentlemen. So first, I apologize for the temperature. We put the fans in there. I have the operations division working on that. There were some power failures over the weekend. The air conditioning shut down. It had to be started. Sheriff's officers were here yesterday, told me the building was unbearable, so it's better today. But obviously, we're not going to keep you confined in there. If for some reason we need a break for more than a couple minutes, we'll have to go back to jury assembly. So I apologize for that. It's a long-standing problem we have here, particularly after holiday weekends, and I guess it was compounded by the power outages. Secondly, I apologize about Friday, but as I told you in the beginning of the case, things come up, schedules are changed, and so I hope everyone got notified in time and it worked out, so I appreciate your cooperation there. Anybody have any concerns or issues you need to bring to my attention? All right, seeing none, then we're going to have another witness or so from the defense, Mr. Gallucci.
Ms. Runt is going to call this witness.
Judge Defense Hall, Sergeant Murphy.
Sergeant Murphy.
Sergeant Murphy.
This witness was not on the witness list, right?
I don't believe so.
No.
Hi, Sergeant. Come on in, sir. Good morning, sir. Good morning. Come on up.
Just watch your steps when you're standing.
If you could raise your right hand, please, sir. The court reporter is going to swear you in directly in front of you.
You solemnly swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you. Have a seat, please. Please state your full name and spell your last name.
Charles Murphy Jr., M-U-P-H-Y.
And you're with Seabright Police Department in Monmouth County?
Yes, sir.
So, ladies and gentlemen, this witness This witness's name may have been inadvertently left off the witness list. So he's with the Seabright Police Department, which is in Monmouth County. But he was mentioned in the case, so both sides agree that he can be called. I asked you a question during jury selection if you knew any of the witnesses or recognized the names of any of the witnesses. Anybody who recognizes or knows this witness, would you please tell us now? All right. Seeing nothing, and everybody satisfied?
Yes, Judge.
Thank you. Ms. Ferranti.
Thank you, Your Honor. Good morning, Sergeant.
Morning, ma'am.
How long have you worked for the Seabright Police Department?
Full-time since 2006, including my special time 2003.
And how long have you been a sergeant?
2017.
Now, what was the extent of your involvement, if any, on this matter?
I was part of the team that was put together to place the defendant in custody that morning.
Defendant being Mr. Gregor.
Yes, sir.
And when you placed Mr. Gregor in custody, when was that?
I don't recall the specific date, March of 2022, I believe.
March of 2022. And during that time, did you have what's known as a body-worn camera?
Yes, ma'am.
Where were you wearing it that day?
It would be on the outside of my plate carrier.
And for the jury, can you describe how you would activate your body-worn camera?
Sure. It's just a double click. We use the Axon body camera system, the same thing that the sheriff's officers in the room are wearing.
And how would you shut it off?
Long press of the button.
Under what circumstances would you activate it?
So we are required by policy to activate it anytime we have contact with the public, outside of just routine discussion.
And so once that contact is completed, you then deactivate it?
Yes, ma'am.
Now, if you remember, when was the last time that you saw your body-worn camera video in this matter?
About an hour ago when you showed me.
In the hallway?
Yes, ma'am.
Now, prior to arriving today, did you watch the body-worn camera?
I did when I received the subpoena last week.
Do you recall what time you made the arrest?
It was in the 7 o'clock hour.
Of the morning?
Yeah.
So sometime in March of 2022, you arrested Mr. Gregor.
Yes, ma'am.
Do you recall the length of interaction you had with Mr. Gregor during that arrest?
I would say 5 minutes.
And how long, well, where did you see Mr. Gregor?
The initial contact I made with him was walking down Ocean Avenue on the sidewalk.
When you say Ocean Avenue, that's in Seabright?
Yes, ma'am.
In the state of New Jersey?
Yep.
And this is again March 2022.
I believe so, yeah.
When you approached Mr. Gregor, what was his physical reaction?
There was really no reaction to me when I got out of the car. I jumped out of the car real quick, gave him a quick order of turn around, which he complied.
So when you gave him the order to turn around and you said he complied, what did he do?
He turned around, and I immediately put him in the handcuffs from that point on.
So between the time you step out of your vehicle to the time you place him in handcuffs, how much time had passed?
Seconds.
And you said the whole interaction was 5 minutes?
From the point where I jumped out of my vehicle to when he was turned over to Barnegat and placed into the rear of the Barnegat patrol vehicle was probably about 5 minutes.
And how long from your initial approach of Mr. Gregor until Mr. Gregor is now placed into a vehicle?
Again, it was probably about that 5 minutes.
5 minutes.
Yeah.
Have 1 second.
Certainly.
One more question. Was Mr. Gregor carrying anything when you approached him?
I don't recall if there was anything in his hand. I actually do maybe a water bottle and a cell phone.
And when you ordered him to turn around, did he place those down on the ground?
I believe so. I'm sure the camera that you're about to show will show that, but I can't say definitively.
If you were to watch the body-worn camera again, would that refresh your
Sure.
recollection? Judge has permission to play.
Well, I think you need to show him the exhibit first. And
I'm going to ask.
Do we have a transcript, Your Honor?
do we have a transcript?
Dialogue on it? No, I'm asking, are we going to have a transcript with it, or?
Transcript.
Any concerns about any statements inappropriate on either side? All right. All right. So show him the exhibit and
Judge, can I approach?
yes.
Officer, I'm going to ask that you take a look at that USB and let me know when you're ready.
I'm ready.
What do you recognize that USB to be?
This appears to be the same one that you showed me out in the hallway before.
Earlier
That
today?
earlier today that contained the body-worn camera
And
footage.
the body-worn camera that you saw on that new USB, was it the same body-worn camera that your body-worn camera captured back in March of '22 during Mr. Gregor's arrest?
Yes, ma'am.
Were there any changes?
No.
Was it a fair and accurate depiction of the arrest you made and participated in March of 2022?
Yes, ma'am.
Judge, I'm going to ask that it be admitted to evidence as D17.
Any objection?
No objection.
D17 in evidence.
To my what?
You didn't say.
Judge, I'm going to need a little time to assist.
All right, you can't put it in your own laptop?
I'll put it on my laptop.
Yes, you
It
said,
will not be on the projector.
right, so your whole screen will come, it's basically a second screen. So if you just,
That's fine, Judge. I just don't have the HDMI cable people have.
no, it's right there, it's for
I'm
both.
trying to do it.
It's for both of you. That's why it's in the middle between the two council tables, so either side can use it. But whoever thinks it would be, could do it
Where,
more expeditiously.
what is it?
Is that TV on the correct setting? Is it supposed to be an HDMI 2? Screen says 1, the top said 2.
And that's not something we could fix ourselves.
Got it, sir. Thank you, sir. If you could take a look for us, it's not hooking up to the laptops.
My laptop, sir. Thank you, sir.
Can I ask you just to stand by for a minute to make sure this actually plays?
Officer, the body-worn camera you testified to before, D17 in evidence, what's on the screen, do you recognize it?
Yes, ma'am.
On the top right corner of that body-worn camera, what would you describe that information to be?
That's just the metadata information, date, time, the serial number of the body camera I was wearing.
Now that you've seen the date and time, does that refresh your memory when it comes to the date that this happened?
Yes, ma'am.
What was the date that you approached Mr. Gregor and made an arrest?
9 March of 2022.
Thank you. And I'm sorry, we were actually going to go over what Mr. Gregor may have been holding, correct?
That's where we kind of left off.
And officer, right now, fair to say there's no sound on your body-worn camera?
No, ma'am.
Why is that?
It's the pre-record 30 seconds prior to me activating the device. Captures video only.
I'm just going to continue to play. Officer, having seen that portion of the body-worn camera that you were wearing that day, does that refresh your recollection as to what Mr. Gregor had on him that day?
Yes, ma'am.
What did he have on him that day?
So he was carrying a water bottle right hand, and then he had his cell phone in his left pocket.
Thank you. No further questions, Judge.
Thank you. Anything from the state?
Jamie, do you want this?
I'll give it back to you in a second. Hi, Sergeant Murphy.
Hey?
You never saw the treadmill video that we all saw in this case, right?
I didn't even know there was treadmill video.
And you know nothing about the vacations the defendant took prior to his arrest on this date, right?
Objection, Judge.
Sustained.
You know nothing about this case other than what you were called to do on March 9th of 2022, right?
Correct.
You made reference to a team responding for the arrest that day, right?
Yes, ma'am.
Does the team mean that there were a lot of officers present?
There was 5 from my agency, plus the Barnegat officers, the Ocean County prosecutor's office. There was a couple Ocean County sheriffs there.
Would it be fair to say between 10 and 15 police officers?
I don't want to testify to the amount, but there was 5 of us plus all them.
Okay.
I would say 10 at least minimum would be a good number.
Fair enough. And just to, I guess, orient us geographically, Seabright is near Sandy Hook, right?
Yes, ma'am.
The location of where the arrest took place, is it essentially on a sandbar?
It's pretty much how I refer to Seabright as a glorified sandbar. Yeah.
There's water all around?
2 sides,
So there's nowhere to go other than the water, right?
north or south, which north puts you into Sandy Hook, south puts you into Monmouth Beach.
I have no additional questions.
Thank you. Any recross? I'm sorry, redirect?
Yes, briefly.
Go ahead.
Sergeant, when you refer to team members, is it fair to say that some of those team members were on the radio?
We weren't using a radio, we were using an application.
An application. Is that the background sounds we're hearing
Yes, ma'am.
during the course of the video?
Yep,
Some of the team members were on the application, correct?
correct. That's how we were communicating amongst all of us.
No further questions.
Anything else?
No, thank you, Your Honor.
Officer, thanks for coming to Ocean County.
Thanks, Your Honor.
Take care.
Good day.
Thank you, Sergeant.
Does the defense have another witness?
Yes, Judge.
Please go ahead.
We call Dr. Michael Bod.
Thank you. Dr. Baden?
Dr. Bott?
I've got more coming.
Okay.
Morning, doctor. Come on in. Morning.
Morning, sir. Just step, sir. Orders for you. Great.
Morning, Doc. You can remain standing, raise your right hand, and the court report will administer the oath, sir.
Do you solemnly swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Yes, sir.
Thank you.
Proceed. Would you please state your full name and spell your last name?
Michael Meyer, M-E-Y-E-R, Baden, B-A-D-E-N.
Thank you, doctor. Mr. Gallucci.
Thank you, Judge. Good morning, Doctor. How are you?
Thirsty. Thank you.
Take a sip of water.
Thank you.
You're welcome. How are you now?
I feel better. Thank
Good,
you.
Good. Doctor, can you tell this jury what type of doctor you are?
I'm a forensic pathologist.
And can you tell this jury if you went to college?
Yes, I'm a graduate of the City College of New York
And when, go ahead.
and New York University School of Medicine, where I got an MD degree. I was then intern, resident, and chief resident, first in internal medicine, then in pathology at Bellevue Hospital Medical Center in New York City.
What's the difference between internal medicine and pathology?
Well, the big difference is internal medicine is dealing with living patients, and pathology is mostly dealing with dead patients.
So you've dealt with the living and the dead.
That's correct.
Okay. In those internships, were you supervised by anybody in particular?
Oh, sure. Lots of supervision.
Okay. Were any of them Dr. Andre Korno?
Yeah, 2 of my mentors had just won the Nobel Prize in medicine for heart disease. Dr. Kurnan and some other members of the group, Dickinson Richards.
So when you did your internship, you did it in heart and lung?
Well, I did it in all internal medicine diseases that comes to a large community hospital, but there was special knowledge in heart and lung disease.
Okay. And did you also do a residency?
Yes, I did. That was a residency, and then I changed to pathology and did pathology residency and chief residency.
So you did a residency in internal medicine, and then you did a residency in pathology.
Yes.
Okay. And are you a licensed medical doctor?
Yeah, I'm licensed to practice medicine currently in the state of New York.
Okay. Have you held any professional positions?
Yes, well, when I finished my training at Bellevue Hospital, I became a full-time medical examiner for the city of New York. And I worked there 25 years in the U.S. Medical, in the New York City Medical Examiner's Office, reaching the role of chief medical examiner. And then I transferred and became the chief forensic pathologist for the New York State Police, which I continued for about 25 years. And I've been retired since 2012, and I'm in a private practice of medicine, of forensic pathology.
And did you have any teaching appointments?
Yes, I had professorial appointments teaching at New York University School of Medicine, Albert Einstein, Albany Medical College, and at New York Law School and John Jay School of Criminal Justice in New York City. In all these areas, I would talk about how forensic pathology contributes to medicine and to the law enforcement.
So you said you taught at New York Law School?
Yes.
What did you teach at New York Law School?
I taught a course on forensic medicine, how the law, being a lawyer also can encompass a lot of relationship with physicians in certain kinds of matters.
Now, in addition to your teaching appointments, did you have any governmental appointments?
Yes, I was. I held various committee and commission assignments in New York City as when I was medical examiner, including involvement with drug abuse and child abuse investigations. On a state level, I am still appointed by the governor of New York to look into deaths and health care given to persons in special needs who are in placement with various state and city agencies that take care of children largely and also elderly people where issues come up as to treatment and cause of death. On a federal level, I was asked to be the chief forensic pathologist by the U.S. Congress, House of Representatives, on a special committee that was set up to reinvestigate the deaths of President John F. Kennedy and Dr. Martin Luther King. And I've been a consultant to various federal agencies in mostly death investigations, the FBI, and other such agencies.
Have you received any honors?
Yes.
What are some of your honors? You don't have to go through.
No. I've had quite a number of honors from the American Academy of Forensic Sciences. I've been given special honors from the Attorney General of the United States in investigations into deaths in Veterans Administration, suspicious veteran administration deaths, and I had a Best Teacher award back in medical school.
Have you ever been published?
Yes, I've been published some 80 or so articles and a couple of books and a number of chapters in textbooks on forensic pathology.
By the way, have you ever been published on child abuse?
I'm sorry?
On child abuse. Have you ever been published on child
Yeah,
abuse?
I've written some papers on child abuse, done a lot of lecturing about child abuse to law enforcement and medical organizations.
Have you given any lectures?
Well, look, yes,
About how many?
more than 100 lectures on various things.
Have you ever lectured on child abuse?
Yes,
Have you ever lectured on blunt force trauma?
yes,
Have you ever lectured on forensic pathology?
yes.
Have you ever worked in the pediatric community?
Pardon me?
Have you ever worked in the pediatric community?
Well, I spent 3 months in a pediatric rotation when I was a medical student, but I have worked on various child abuse committees in the city of New York and in the state of New York. In fact, when I worked with the New York State Police, I was available to come to emergency rooms when a child came in and there was an issue as to whether or not an injury was due to abuse or to some accidental innocent cause. So I'd be called in to evaluate that.
Have you ever appeared on television?
Yes,
Did you have your own show on HBO?
yes.
What was the name of that show?
Autopsy.
Have you done an autopsy?
Yes.
Approximately how many?
I've done more than 20,000 medical legal autopsies.
Now, you're in a courtroom. Have you ever testified in a courtroom before?
Yes, including this courtroom. I mean, maybe in the old building, but in Ocean County.
Okay. How many times do you think you've testified in courtrooms?
Over the 50, 60 years, many hundreds of times.
Have you ever testified for the prosecution?
Usually, most of my testimony has been for the prosecution.
Have you ever testified for defense attorney?
Yes.
And you said you've testified before in New Jersey.
Yes.
Can you tell us some of the cases you've testified on?
Well, the ones that come to mind here was Vincent Craparata, where I testified some years ago for the Attorney General's office in a mafia killing case in the Ocean County courtroom. And for other cases, in fact, I met an attorney outside that I testified with him 25 years ago in this courtroom on a drowning homicide.
Your Honor, I'm looking to qualify Dr. Bodden as an expert in both forensic pathology and child abuse.
No objection, Judge. Thank you.
The court grants the defense application for Dr. Bodden to testify as an expert witness in forensic pathology and child abuse. Ladies and gentlemen, as you will recall, as a general rule, witnesses can only testify as to facts known by them. This rule ordinarily does not permit the opinion of a witness to be received as evidence. However, an exception to this rule exists in the case of an expert who may give his opinion as to any matter in which he is versed, which is material to the case. In legal terminology, an expert witness is a witness who has some special knowledge, skill, experience, or training that is not possessed by the ordinary juror, and who thus may be able to provide assistance to the jury in understanding the evidence presented and determining the facts of the case. In this case, the defense has called Dr. Bodden as an expert. You are not bound by such expert's opinion, but you should consider each opinion and give it the weight to which you deem it is entitled, whether that be great or slight, or you may reject it. In examining each opinion, you may consider the reasons given for it, if any, and you may also consider the qualifications and credibility of the expert. It is always within the special function of the jury to determine whether the facts on which the answer or testimony of an expert is based actually exist. The value or weight of the opinion of the expert is dependent upon and is no stronger than the facts on which it is based. In other words, the probative value of the opinion will depend upon whether from all the evidence in this case you find that those facts are true. You may, in fact, determine from the evidence in this case that the facts that form the basis of the opinion are true, are not true, or are true in part only. And in light of such findings, you should decide what effect such determination has upon the weight of the opinion to be given to the expert. Your acceptance or rejection of the expert opinion will depend, therefore, to some extent on your findings as to the truth of the facts relied upon. The ultimate determination of whether or not the state has proven the defendant's guilt beyond a reasonable doubt to be made only by the jury. Thank you. Mr. Gallucci.
Thank you, sir.
I'm back. How are you?
Okay, thank you.
Need more water or are you good?
I'm fine.
All right. We discussed autopsies while I was trying to qualify you as an expert. Once again, how many autopsies do you believe you've performed in your career?
More than 20,000.
More than 20,000. Have any of those autopsies been on children?
Yes.
About how many have been on children?
On children over the years, maybe close to 1,000, many hundreds.
Okay. Now, I contacted you to discuss the case of the death of Corey Mitchell, did I not?
Yes.
Okay. And did you review materials that I sent you with an eye towards rendering an opinion as to the cause and manner of death of Corey Mitchell?
Yes.
Okay. And did you prepare a report of your findings and opinions regarding Corey's death?
I did.
Now, did you perform the autopsy in this case?
No.
Although you did not perform the autopsy, were you able to develop an opinion as to the cause and manner of death?
Yes.
Do you know who did perform the autopsy in this case?
Dr. Ragasa.
Okay. Did you review the autopsy report prepared by Dr. Ragasa?
Absolutely, yes.
And do you know when that was prepared?
Yes, that autopsy was done 14 hours after the death of Corey.
Okay. Did you also review medical records from IV Pediatrics?
Yes.
Did you review medical records from Community Medical Health Hospital?
I did.
Did you review medical records from Jersey Shore Medical Center?
Yes.
Did you review medical records from Southern State Medical Center?
Yes.
Did you review what's called histological slides?
Yes.
And what are those?
Those are glass slides that most people come in contact with in school, where very thin slices of tissue are placed on and can be viewed under a microscope in order to increase the ability to see what's present. And that's commonly, those slides are commonly made in autopsy, after autopsies of the various tissues that are seen with the naked eye, because they give more information when seen under very much higher magnification.
Did you review the autopsy photos?
Yes.
Did you review any police documentation?
Yes.
Okay. Did you review a 33-second video that was taken on April 2nd, 2021?
Yes.
Okay. Did you review a photograph of Corey asleep in his father's arms on April 2nd, 2021 at approximately 2:02 in the afternoon?
Yes.
Did you review a Dr. Andrew report?
I did.
Did you review a Dr. Feingold's report?
Yes.
Did you review a video of a treadmill from a gym on March 20th of 2021?
Yes.
Did you review an additional video from the same gym taken on March 29th, 2021?
I did.
Okay. Now, do you have an opinion after you reviewed all the material in regard to Corey's cause of death?
I do.
Can you tell the jurors what that opinion is as to Corey's cause of death?
I think that Corey's cause of death has been confused because of extensive injuries caused by the CPR process, that I agree with a part of Dr. Ragasa's cause of death that indicates injuries to the heart and other organs, which I think is are typical vigorous CPR injuries. And I don't agree with that part, but I do agree with the inflammation and sepsis part of his diagnosis. The inflammation and sepsis part of Dr. Ragasa's diagnosis refers to inflammation in the lung and the finding on culture of bacteria in the lung that could cause pneumonia and sepsis. So I think my cause of death is different than Dr. Ragasa's in recognizing, in my opinion, that the injuries are all CPR injuries. Nobody can live for more than 2 minutes with a 1.5 inch laceration of the heart, for example. And I do agree that the most likely cause of death is the lung inflammation, the bacterial capture of what the bacteria was, and his symptoms, the symptoms of shortness of breath, cyanosis, means a bluish color due to low oxygen, finding in the hospital that he had an 85% oxygen level, which is very low. All of us here would have about 97% or higher. The high white count, 29,000, mostly polymorphonuclear cells, which are the cells that respond to a bacterial infection. And then what I also base my opinion on is the CAT scan finding of pneumonia also present. So I think all together, the most likely cause of death was a very severe, rapid pneumonia. There are other causes that could also occur. Sudden, unexplained death in children syndrome occurs, like sudden infant death syndrome that causes baby deaths, and it's not clear what the cause of death is. Same thing with children, 3, 4, 5, 6 years old, can die suddenly, cause of death being the heart stops, and not knowing the reason for that, and that's called sudden unexplained death in children syndrome, which occurs many hundreds of times a year in this country. And there may be other types of infectious diseases that sometimes don't get caught on autopsies, but they're all infectious diseases, some affecting the lungs, and I just feel that the injuries to the lung, liver, and mostly the heart are just typical vigorous, especially vigorous CPR, which is the very nature of what CPR does. It squeezes the heart 100 times a minute.
I'm going to get into that, Doctor. Did you form an opinion as to the manner of death?
Well, my opinion would be that the manner of death, for all the information we have, is natural.
Okay. Now, there are 5 manners of death, right?
Yes.
Okay. And natural is one of those 5?
Yes.
Okay. So, you keep talking about CPR, CPR, CPR. Let's just get to the meat of it. What is CPR?
CPR refers to compression of the chest to force the heart to pump blood. As we sit here, most of us, our heart is pumping blood around 60, 70 times a minute. And that causes a squeezing of the whole heart. If the heart stops and CPR is the only way to get it started again, chest compression, which is severe enough to press on the heart to pump blood, is the only means of keeping the person alive. And that occurs because the sternum, the chest bone, has to be pushed down far enough to touch the heart, to go right up against the heart and squeeze it against the spine bones behind. So every compression during CPR physically squeezes the heart against the spine. And that will then push out the blood, which is essential because if it stops going out for 5 or 10 minutes, you wind up with a brain death, so that has to be done, and it's done vigorously, but it can also cause damage. Now, when I was chief medical examiner in New York City, the idea of EMS CPR was developed in New York City, 1979, with the realization that CPR causes damage, but the alternative is the person's going to be dead. So that the risk is always taken that CPR can cause damage to the heart, to the liver, to the lungs, and to bones, fracturing bones and sternum, but that those injuries are compatible with life, whereas if the CPR wasn't done, the person would be dead because of the heart stoppage.
So it's more beneficial than dying.
Yes, the only way to keep it, but depending on how vigorous the CPR is, you get more injury. General studies show that about 60% of CPRs that don't revive the patient, 60%. So there are injuries. Most of them are bone injuries or fractures, but about 35% are heart injuries, bruising on the heart. From what I calculated, CPR was done for about 49 minutes. Usually it stopped after about 18, 20 minutes. There was concern about Corey. It was kept up for 49 minutes at 100 compressions a minute, to get the heart pumping blood. So that's over 4,000 impacts that heart had against the sternum and the spine, and it is understandable how these injuries would occur. And that is why my opinion is that what's being described, and I also found it of interest that Dr. Regassa, when he did the autopsy, refused to put that down on the cause of death. And he includes in the autopsy, under heart, question mark CPR, right in the autopsy report on the first day. He was concerned about CPR causing all the heart injuries, and it wasn't until 14 months later that he changed it to homicide.
Now, do children, like a person of my height, I'm 5'6", about 190 on a good day, would CPR be done differently to somebody like me than to a child?
Well, yeah, there's a difference in how you do the CPR to persons as they get older. The older we get, the more brittle our bones become and the more breakable they are. And the child, like Corey, the ribs are all bendable. They're like cartilage in our ears, and so they're very easy to push down. But the bottom line has to be, it's got to be pushed down about 2 inches down to squeeze the heart against the spine so that the blood is pumped out of the heart. And if that isn't done, then the heart, and that's done usually until a normal sinus rhythm occurs. And that often happens, especially in people in hospitals, that the CPR be done, and usually within 5, 10, 15 minutes, you get a normal pulse back, and then you can stop the CPR because now the heart is going back to pumping blood normally. But if the heart doesn't pump blood normally, it's kept up, and in this situation, it was kept up much longer than usual.
So
and
you said much longer than usual. What would be normal? What would be usual CPR on a 6-year-old child?
Well, normally, if the heart doesn't respond by developing its own normal sinus rhythm, the CPR will stop. That is, it's fruitless usually after 20 minutes.
And how long was CPR conducted for?
49 minutes.
And that's unusual. Now, can people die from CPR?
Well, not usually, because they're already dead. When the CPR can only be started after the heart stops. So once the heart stops, the person is dead, and then the alternative is, can we revive the heart to start beating again? And CPR sometimes starts the heart again after 5 or 10 minutes. But if it doesn't restart the heart, it becomes of no value afterwards. But it isn't that the CPR caused the death. It's just the fact that the heart does not restart beating that means the person is dead.
Can you explain to the jury how the heart works?
Well, the heart has 4 chambers, as we learned. The blood comes in through a vein into the right atrium, goes down into the right ventricle, and gets pumped up through the lungs. It's an amazing thing. I mean, every time I do an autopsy to see how this is done and how each cell in the body knows where to go is a miracle of the body. But it comes, so it brings back the blood that's used up its oxygen, goes back into the right ventricle, pumps it into the lungs, where the carbon dioxide is removed and oxygen is replaced on the red blood cells. And then it goes into the left atrium and the left ventricle, and that's the workhorse of the heart, the left ventricle, which then pumps the blood to every cell in the body. Every cell in our body gets oxygen all the time, or else they're going to die. So that the left ventricle is the main pusher of blood around the lung. If the heart stops, then after about 5 minutes, without any brain flowing to without any oxygen going to the brain cells start to die. It's amazing. The brain is about 25%. No, the brain uses about 25% of all the oxygen, even though it's about 2% of the weight of the heart. So the brain is the organ that needs oxygen the most. So when the oxygen is cut off from the brain for more than 5 minutes, then brain cells start to die, and they don't rejuvenate. Some cells in the body, like the liver cells, will reform, but not in the brain, permanent damage. And that's why you wind up sometimes with vigorous CPR that after the brain dies, then the other organs of the body are okay, because if they get oxygen, the heart and all the other organs can do okay with less oxygen. And you wind up with people who wind up in bed and in hospitals for long periods of time, but they're able to be taken care of, but they're unable to function because brain death is permanent.
Now, you spoke about the blood and how it goes in and out and gets reoxygenated and comes on back. Is there like an electrical system that the heart has?
Yeah, well, the electrical system of the heart has to do with the rhythm of the heart. The way the heart functions is that there's an electric circuit, about less than 1%, 98% of the heart is muscle, and about less than 1% is nerves. And the nerves cause the atria and the ventricles to function. If something goes wrong with the atria, you can get atrial fibrillation. And atrial fibrillation means there's something wrong with the electric circuit in the heart, but it's not very important because the ventricles have their own rhythm, and it's the ventricles that are the workhorses. And so the blood goes into the atria, and it's pumped down by the electrical stimulation into the ventricles, and then by their ventricle stimulation, they get pumped out to the body. And every cell in the heart has nerve cells that go to it to make them function. And if the heart stops beating, it means that the electric circuits have stopped functioning, and they have to be restarted. And usually, getting oxygen back to them sometimes causes them to restart, and that will restart the normal heart rhythm.
Now, doctor, there's been a lot made about an injury to Corey's heart through this trial. In the medical examiner's report, I believe it's described as a 1.5-inch laceration to the heart. Do you have an opinion as to how that 1.5-inch laceration to the heart occurred?
My opinion is that laceration occurred from continuous CPR, compression of the heart, between the sternum, the breastbone, and the spine that happens with sufficient compression of the heart. That the heart has no place to go between the sternum and the spine, the thoracic spine, so that injuries are common in the heart, and lacerations of the heart are not the most common, but can occur.
So now, if somebody was to sustain a 1.5-inch laceration to the heart, would that be something that could kill them?
Absolutely.
And how long would it take a person to die had they received a 1/2 laceration to the heart?
Well, the heart would stop beating within a minute or two. That is, the heart needs the electrical circuits in the heart to be functioning, and not only does a laceration cut through the muscle, but also through all the nerves in that area, and which would stop the electrical circuits in the heart.
So the laceration sustained in this case would have killed a person within minutes?
Yes.
Would it have been a bleed out or an electrical problem?
Well, not a bleed out, because there doesn't have to be a breakage of if there's a breakage of the outer blood vessels, they're very small capillaries on the outside, you can get bleeding. So there would be a few blood vessels that are damaged on the outside of the heart. those would bleed, but they bleed slowly, and if somebody dies within 2 or 3 minutes, it would bleed very little. If the person lived for a while, there'd be a slow leakage of blood, a slow beating of blood that would fill up the pericardial sac, the sac in which the heart is encased, so that if they were bleeding from the heart in any way, there'd be a lot of blood in the pericardial sac, whereas it wasn't here, and that's because the heart stopped beating right away. When the heart stopped beating, that's the end of blood coming into that sac.
Now, if that injury had occurred at 2:02 in the afternoon up until 3:43 in the afternoon, that's when Mr. Gregor arrived at the hospital with Corey, would he have been dead already?
He couldn't live more than 2 minutes with that kind of injury. Yes, absolutely.
Now, can a laceration to the heart caused by CPR be considered a blunt force injury?
Yes.
Did Corey die from CPR?
No. CPR didn't restore life in him, but he didn't die from it.
Now, Dr. Andrew came here the other day and he testified at great length about something he abbreviated, he called them polys. What's the formal name of them?
Polymorphonuclear white blood cells. There are a number of different immune cells, and polymorphonuclear cells are all part of the white blood cell category, and they're the ones that respond to infection.
So, can you explain to the jury why Corey had an increase in polys?
My opinion certainly is that the increase in polys indicates that there was a infection in the heart, infection in the body. The infection can be anywhere. There was an infection in the body, and that Dr. Ragasa showed by his culture that was caused by Staphylococcus aureus, by that particular bacterium, by doing the culture at the time of the autopsy.
So let me ask you, well, I'm going to get into autopsies in a minute, but let's stay with the CPR for a second. So Dr. Andrews also testified that it was his opinion that the injury to the heart and liver were not caused by CPR because of the presence of the polys. Do you agree with that opinion?
No, what that would refer to is that often after an injury, the body's white blood cells start coming to an injured area. However, the polys are abundant in the bloodstream, so that what Dr. Ragasa, I looked at the same slides. The only polys that were in the heart were polys that were in the bloodstream. They weren't polys that were responding to the injured muscle, which is an indication that the injured muscle and death occurred very quickly.
So when you say the injured muscle, the heart's the muscle?
The injured heart muscle, yes.
So now let me ask you this. Can you tell the jury what exactly an autopsy is?
Well, an autopsy consists of many parts. Most people are familiar with the external and internal examination that occurs at the time of the physical autopsy. There are many attendant studies that occur. Photographs are taken to identify whatever things, items of significance. Toxicology is commonly done on appropriate blood or tissues as needed. There are DNA studies that can be done. There are microscopic studies that are done. X-rays are common. In fact, the New York City Medical Examiner's Office had a large room that was an X-ray room, as many medical examiner's offices have, right next to the autopsy room to take take X-rays of autopsies being done, especially of babies, because there are many issues, injuries in babies, like in the extremities, that are not usually part of an autopsy, but that show up very nicely on X-ray. So what I say, so that a part of the autopsy is taking the X-rays and microscopic slides, and more recently, since I left New York City, CAT scans have become prominent in medical examiners' offices, those that can afford them, because studies have shown that one CAT scan that can do a digital autopsy can perform the work of 2 medical examiners, so that they're becoming more. There's a need for more medical examiners. A lot of doctors don't like to do medical examiner work, so that they can be very, very helpful. When we die, everything's the same. When we die, bones, skin, muscles, organs are all the same. What changes is the chemicals in the blood, the enzymes and the electrolytes and all. There's a change in the chemistry of the body after we die, but not of the organs, so that CAT scans after death give the same and sometimes better indication of any damage or injury that there is to an organ than the autopsy itself.
Doctor, I have S58, which is the state's picture of the heart. Let's get back to the heart for just 1 second. Would this help you show the jury what the laceration is and how it would affect the heart?
I haven't seen that.
Okay, take a look at it.
Yeah, I've seen this before.
All right, thank you.
There's a lot of white spots on this, but I see that there's an area of injury here.
Can you maybe hold it up and point it out to the jury?
Well, I could circle it with something if you'd like,
Well,
but
they don't like their evidence touched.
well,
So they've already crossed
there's
that.
right near the bottom, the apex of the heart, there's an injury that I guess was shown to the jury in the past. It's hard to see the color differentiation.
But that's the 1.5-inch laceration that we're
Yes.
talking about. And that's the injury that you would have died almost immediately from.
Yes.
Okay. Let's get back to the autopsy. You just discussed that the autopsy is more than just a dissection of the body, right?
That's correct.
There are additional tests that are called for, right?
Yes.
And you just discussed one of those tests is a CAT scan, right?
Yes, that's more recent because it's expensive for medical examiners to get a CAT scan and the necessary precautions and area to put the CAT scan. But a number of medical examiners' offices around the country have installed CAT scans.
How about X-rays?
X-rays, very, very helpful, and that's the kind of radiology I'm familiar with, because when the medical examiner's office was built in the 1960s, the room right next to the morgue where the autopsies are done was the X-ray room, because it was used so frequently as an assist in the performance of autopsies.
By the way, if you know, didn't Dr. Andrews work in that particular office that had the building with the x-rays right next to it?
That's my understanding, yes. That was after I left.
So, in addition to x-rays and CAT scans, could they also request medical examiner as part of the autopsy, request any lab tests like a culture or blood work or anything like that done?
Well, cultures are part of doing an autopsy. If the doctor thinks there's an infection, it's important to try and find out what the infecting agent is. So, as a public health measure, to know what is causing the infection. So that's why cultures are done, and special tests can be done looking for chemicals in the blood that might be specific for certain natural diseases that have abnormal components in them. That can be done.
So what exactly is a person that's a medical examiner doing when they perform an autopsy? What are they doing?
Well, the medical examiner is trying to determine cause of death and aspects of the death that can be helpful to the family. There are genetic things that come up that should be looked for, and so that the family will have the ability to know how a loved one died and what effect it may have on the children and the grandchildren, the different kinds of genetic diseases. In addition to that, most autopsies are just for information for the family. When deaths are unnatural, homicide, suicide, accidental deaths, they have a great societal impact. So often the society is informed of certain kinds of deaths. Certainly any homicide is always reported to the district attorney's office and to consult with the district attorney's office. If there's a disease that can be contagious, we've gone through the COVID thing where so much attention was paid to medical examiners and autopsies. It's important to know the extent of a contagious disease from a public health measure. So the medical examiner's office is not just a criminal justice type agency, but it's also more so a public health agency that is meant to inform public health officials of the latest reasons that injury and death occur.
So is the medical examiner who performs an autopsy an integral part of the investigation?
Of the criminal, in general, yes. Be it public health or be a criminal justice system, yes, the autopsy becomes an important part of that investigation.
So would you say that the medical examiner is like the detective of the dead?
Some have been referred to that, yes, that they're dead people. Quincy was a dead person detective.
So now, we had a nice infectious disease specialist come in here, and she gave some testimony about CAT scans after death to the lung being of no value. Do you agree with that opinion?
No, they are of value. It's some doctors may know that CAT scans are done on dead people, so certainly CAT scans are only a rather modern device, so that old timers may not know that CAT scans are used in post-mortem investigations.
Can you see a pneumonia on a CAT scan?
Yes, you can see evidence of a pneumonia, yes.
Okay. Now, doesn't the body decompose after death?
With time, it decomposes, yes. That takes time.
How much time?
Well, it depends. It takes, in hot weather, within a few days, a dead body exposed to hot weather for a few days can start to decompose.
Now, during COVID, we saw pictures of refrigerated trucks
Yes.
filled with bodies. Do you know why the bodies were placed in refrigerated trucks?
Yes, in all medical examiners' offices have refrigerated areas because placing a body in refrigeration stops the decomposition. Bacteria don't function below 39 degrees Fahrenheit. So in general, medical examiners' offices have refrigeration units for the bodies that come that run around 36, 37, above freezing, 36, 37 degrees Fahrenheit. So at that level, decomposition stops.
Was Corey's body refrigerated after he died?
Yes.
Corey went through a vigorous autopsy. Am I correct?
Yes, an extensive autopsy, yes.
And that was performed, do you know who performed that? Was that Dr. Ragasa?
Dr. Ragasa did the autopsy.
And he was the medical examiner from Ocean that did that?
Yes.
Okay. Now, let's discuss some of the findings that we see on an autopsy, on Corey's autopsy. Was there a CAT scan done on Corey's during Corey's autopsy?
CAT scan was not done during the autopsy. What happened was when the medical examiner's office was notified about the death of Corey from Southern Ocean Medical Center, the medical examiner investigator responded to the hospital. It so happened that the investigator was a physician, a Dr. Larkin, who was a family care physician. And when he went there, he looked through the chart, was concerned about possibility of a pneumonia or infection, so he requested a CAT scan. New Jersey doesn't have a CAT scan facility, so if the body came to the medical examiner's office, a CAT scan couldn't be done. So that Dr. Larkin requested a CAT scan while the body was still present in South Ocean Hospital, and that was done there before the autopsy was done.
So the CAT scan of the lung was actually done prior to the autopsy?
Yes.
Do you know how soon after Corey passed that CAT scan was done?
It was done within a few hours after. The CAT scan was done within a few hours, and I think that the autopsy was done about 14 hours after death. So it would have been done 2 hours perhaps after death.
Now, did that CAT scan reveal anything that you used to form your opinion?
Yes, it revealed that there were certain changes in the lung on the CAT scan that suggested pneumonia.
What were those changes? Do you know?
Yeah, filling of alveoli, the air cells with fluid.
Did the CAT scan also reveal extensive airspace disease identified through both lungs, however worse on the right?
Yes, that's what I was referring to.
And what does that mean? What is extensive airspace disease?
Well, that's an indication that that's what pneumonias look like. The air spaces are supposed to be filled only with air, the alveoli. And when fluid gets into the air spaces, that causes a pneumonia. So that description that you described it doesn't prove, but it's indication that there's a pneumonia present. And I think that was what Dr. Larkin's opinion was.
Now, the CAT scan also revealed something called diffuse multifocal alveolar air space. Is that the same thing that we just discussed, or is that something different?
Pretty much the same.
Okay. And that is the same, gives you the same indication, right?
Yes.
Now, I don't remember if we went through Dr. Feingold talking about the CAT scan, but I believe we did. Do lungs collapse after death?
No, not initially, not till decomposition sets in. The lungs don't function after death, after the heart stops, so that whatever air or blood is in the lungs stays there. When decomposition sets in, then the bacteria themselves can make changes in the lung that cause other abnormalities in the lung that can be confused with pneumonia, but this CAT scan was done right away before there was any decomposition.
And Dr. Feingold opined that a CAT scan done of the lung after death, that the lung would need to be reinflated in order to get a better view. Is that true?
No, that's not true at all. But I think Dr. Feingold, when Dr. Feingold was training and all, there weren't such a thing as CAT scans. And I think that Dr. Feingold doesn't appreciate that CAT scans are now used and can be very helpful in the autopsy process. And there's a name, digital autopsies are part of what happens at an autopsy nowadays. That wasn't present when she was exposed to autopsies.
Now, in addition to this CAT scan that was done during after Corey's death, during the autopsy, does the medical examiner also go through all of the particular organs in a case?
Yes, the autopsy includes examination of every organ in the body, period.
And that's how we have a lovely picture of the laceration to the heart. Right?
Yes.
Okay. So, did Dr. Ragasa, the ME who did the autopsy, did he look at the lung?
I'm sorry, I got it.
Take your time.
Yes, he looked at the lungs.
Okay. And during Dr. Ragasa's report, did he find that in the lung he found mild to moderate congestion with occasional mild peribronchial, non-specific, acute, and chronic inflammation?
Yes.
And can you tell the jury what that means?
Well, acute inflammation means fresh infection in the area. And that's what he put, that's the only place he uses the word acute inflammation. And he puts that in the cause of death. On his cause of death, he first gives the injuries to the heart, lungs, liver, and then says acute inflammation and sepsis is the second part of his autopsy findings. I agree with the acute inflammation and sepsis being the Staphylococcus bacteria that he identified. I think that part I agree with, but I think the first part is all made during CPR after the child died.
Okay. What is sepsis?
Sepsis is an infection through the body.
So, in addition to the CAT scan, in addition to Dr. Ragasa's findings of the actual lung itself, were there any other studies that were ordered by Dr. Ragasa with respect to the autopsy, such as a culture?
Well, what Dr. Regassa did at the time of the autopsy is he took a culture of the lung. And the only reason he would do that is he wanted to identify the organism that was causing the inflammation in the lung, the pneumonia. Pneumonia is a form of inflammation. And he did that, and the culture, if it's not done properly, can contain lots of bacteria, but when you have just the one bacterium present, that's evidence that it was a proper culture, and that's the only organism that was causing the inflammation in the lung.
So now, during an autopsy, we know that there's going to be a dissection, right?
Yes.
We know that the medical examiner is going to pull out each and every organ and examine it and weigh it, take a picture of it, right?
Yes.
Is a lung culture normally done on every single autopsy?
No.
When would a lung culture be done?
If the medical examiner is trying to identify the agent causing the inflammation.
So, the lung culture, what did it show?
The lung culture showed Staph aureus as the bacteria that was present in the lung that Dr. Regassa went to the trouble to take a sample of.
What is Staph aureus?
It's one of the common drugs around that when it causes infection in children can lead to serious consequences, but it's around us all the time.
Would a blood culture be good at finding pneumonia?
Blood cultures in people who have pneumonia, blood cultures find the bacterium about 5% of the time. So blood cultures used to be widely used when I was in medical school, but are not so widely used. And some hospitals have stopped doing blood cultures at all because it's positive in a very small percentage of the cases, and it itself can lead to a lot of extraneous diagnoses and work if it's incorrect.
So then a lung culture was ordered because it would be the best way to determine whether or not there was actually any bacteria or disease or infection to the lung?
In the bloodstream.
Now, besides the CAT scan that showed pneumonia, and besides the actual looking at the lung that showed signs of infection, and besides the lung culture, we're good? We may need a break.
Yeah, I know. I mean, it's hot here, and I apologize. So I was hoping I was going to take a break after the direct, but certainly you can go as long as you like. But I think we need a break now. It's warm in here. So, ladies and gentlemen, I don't know how long you want to stay in there. If you want a longer break, let me know. We can send you back to jury assembly. But take a little break and get some maybe some water or something like that, and we'll come back in a few minutes. Please don't discuss the case.
All right.
After a little bit, get everybody a break. It's 11:15 a.m. Anything outside the presence of the jury from counsel? I know it is, yeah. I'm going to see what I can do.
It's probably hot under that road, too. We're on break. Couple of minutes. Not allowed to talk.
Back on the record, the jury is still in the jury room. With respect to the temperature, the court has spoken to the trial court administrator and the operations manager about trying to get an additional fan, which we can place near the jury box. And also the operations manager took temperature readings with an electronic device to advise county buildings and grounds. This is the difficulty with county buildings and grounds, who's in another building across the street controlling our temperature and not realizing what the actual temperature is inside the courtroom, despite whatever it may be set on. So it's clearly been uncomfortable. I was trying to keep an eye on juror number 12. He seemed to be paying attention, but then I saw Mr. Gallucci make a gesture, and I looked over, and it looked like juror number 10 was nudging juror number, juror number 9 was nudging juror number 10 to wake up. I did not see him, what I should say is I had been watching generally, and I didn't see him falling asleep until Mr. Gallucci made that motion. So as far as I could tell, it seemed to be a relatively brief occurrence. Counsel have any position on that?
Judge, I happened to be watching them through the whole course and purposely kept walking over to the jury box to try to keep them moving around. And I was most watching him, and at no point did I see him fall asleep.
All right, so you're satisfied? I don't need to take any action?
No action.
State have any position?
No, Judge, thank you.
All right, so the court agrees that there's no evidence any juror missed a substantial portion or really any significant portion of the testimony. It's just that it's uncomfortable in here, and it's not even that hot out. Fortunately, it's not in the 90s. So I've expressed my concern to the trial court administrator about what are we going to do in summertime when it's 95 degrees and this occurs. This is an annual occurrence, by the way. This is not an isolated incident, despite the power outages over the weekend. This is unfortunately an every summer occurrence for us. So if anyone notices any of the jurors appear to be having a difficult time paying attention or nodding off, I'd ask you to please bring it to my attention, and I thank Mr. Gallucci and Sergeant Dugan for doing that. Respected juror number 10. Anything else before we bring jury out? All right, 11:40 a.m. jury out.
Nice and cool in there. In here? You should be having ice cream. Say the thermostat in here is rated 85.
Check that, will you please?
Yeah.
I turned it down.
Okay.
It was. I put it on the lowest it could go this morning, and it was 78 then, so it's gone up obviously. But thank you. You can be seated, everyone. Why don't we bring out the black fan, the newer one that's in there for now. I've asked for a fan to be brought in here to be placed near the jury box for you. Unfortunately, the nearest plug is over in the front, and so it's going to require a long extension cord.
You don't count because you're going to be high.
For it. Unfortunately, it's an annual occurrence. It's usually in July and August when it gets worse, but this is just a common problem we have, and it upsets me when you have people who are willing to put in the time and effort for jury service and you can't even control the temperature of the courtroom. So I'll continue to follow up on it. I think it's inexcusable, and on behalf of the whole judiciary, I apologize to you for it.
It is reading 81.3.
All right, so we need to get it addressed. I said to the county, we need to get it addressed before you reach jury deliberations, because that's uninhabitable to be in there at that time. So I've expressed also that to the trial court administrator, and I'll continue to work on it for you. Now we're going to continue with the questions by Mr. Gallucci.
Thank you, Judge. Welcome back, Doctor.
Thank you.
So, Doctor, I believe we ended where I was talking to you about all of the tests that were done on Corey prior to the autopsy, being the CAT scan, and then during the autopsy, being the actual physical, looking at the different organs, and the lung culture. Now, in addition to all of those things, in the medical records that you reviewed, did you see any other signs that Corey had pneumonia?
Well, the admission signs of shortness of breath, cyanosis, discoloration of the skin, measurement of an 85% oxygen, which is very low, a rapid heart rate. He had a heart rate of 144, which is higher than normal. And then, of course, the very high white blood count that I think by itself indicates some type of infection.
So let's start with the high white blood count. The blood count, I believe, was 29,000. Am I right?
Right.
Okay. What's normal white blood count for a 6-year-old?
Well, about 7,000, 8,000 that most of us have here. It's just the normal white blood count that keeps track of everything going on in our body.
So he was triple.
Yes,
Okay.
more than triple.
So with an increase in, I'm going to try to get this word right, polymorphonuclear cells, right?
Yes,
And we discussed those earlier, right?
yes.
Okay. Now, I know we discussed it, but why do you think that we saw, what's your opinion as to why we saw an increase in the I'll call them polys, in the polys?
Because of a sudden infection present in his body that the white blood count previously at one of the hospitals was normal, and it suddenly shot up to 29,000, which would indicate a beginning infection.
Could it also indicate a injury?
Injury usually doesn't cause that kind of increase in white cells unless it gets infected, then it'll go up.
So let's go back to the blunt force trauma that you opined was due with the blunt force trauma was the CPR that damaged the heart, right? You've already testified, I believe, that's not what killed him, right?
That's correct.
Okay. Could that have been why we see the response in the polys?
Well, he had that response before CPR. When he had a 29,000 white count, his heart was pumping blood. He was alive. And then when he passed away, the white count would not change. It just stayed the same afterwards. It wouldn't increase any more than that.
So to you, your opinion is that's more reflective of an infection than it is to an actual injury.
That's correct.
Now, you also just said used the word cyanosis. What is cyanosis?
Cyanosis is a bluish type of tint to the skin that occurs when the oxygen level goes low. And 85% oxygen measured at the hospital while he was alive is very low. And that he was noticed by health professional people who examined him on admission to South Ocean Hospital that he was cyanotic.
Okay. Now, you also said that he had a pulse rate of 144 beats per minute. What's normal?
Normal would be about 100, and for a child, 110, something like that. It's higher than normal.
What's the significance of that?
Well, that doesn't necessarily mean infection. It means something's going on in his body, and that can be caused a lot of different ways.
Now, Dr. Andrews testified that there was an injury to Corey's liver, although I believe his opinion was that had nothing to do with the cause of death. Did you see an indication that there was an injury to the liver?
Yes, there was an injury to the liver, and it had nothing to do with the cause of death. I agree with that.
Okay. So what do you think caused the injury to the liver?
The vigorous CPR. The liver is right there under the lower part of the chest bone, and that is not uncommonly injured with CPR.
Well, you know, we talked a lot earlier about CPR and heart and injuries caused. What are the typical injuries you see as a result of somebody receiving CPR?
Well, the most typical injury are fractured ribs that occur usually in the older population that more commonly get CPR than the younger population. But it depends on how long the CPR is done and how aggressively it is done.
So you don't see a fractured rib because he's 6 years old, right?
That's right. His ribs are more pliable at 6 years old than as we get older.
So, in addition to the cyanosis, the shortness of breath, the low blood oxygen, high white blood count, I believe Corey also had unequal pupils. What are those?
Unequal pupils would indicate that there was some abnormality in the brain. One of the earliest changes that we can see on the outside of the brain is affects the pupils getting bigger, smaller, reacting abnormally. Would go along with an oxygen deficiency going to the brain.
So, now, we heard testimony from a pediatrician at Ivy Pediatrics. We heard testimony from a doctor, I believe, at Community Health. We heard testimony from another, no, we didn't hear from Community Health. We heard from a pediatrician at Jersey Shore Medical Center. We heard from a nurse, two nurses actually, no doctors, but two nurses from Southern Ocean Methodist Medical Center. And in every single one of those appearances, an Ivy Pediatrics pediatrician looked at him and said that he was a healthy child. He went to Community Health Center. They did some tests. All of those were negative. He went to Jersey Shore Medical Center. They did some more tests. He was evaluated again by a pediatrician. And they gave him basically a clean bill of health. How can you explain that now, when he gets to Southern Ocean Medical Center, he's got this raging infection?
Well, there are a couple of considerations. One is he was brought to all those hospitals because of issues that had arisen as to child abuse, as to the fresh injuries that would require removing the baby from the father. So he went around to the different places. None of them felt that he should be taken away from the other parent. That all their remarks had to do with
Objection, Judge.
the injury. Sorry.
You want to approach that, Barney?
Yes, please.
Thank you, Judge.
Ladies and gentlemen, the objection is sustained. I ask you to strike the testimony about whether or not there was some indication the child should or shouldn't be taken away from one parent or the other. That means even remembering your deliberations, you're not to consider it in reaching any decisions in this case. Thank you. Mr. Bellucci.
So what is the job of a pediatrician in an alleged child abuse case?
Well, the doctor, the pediatrician or the doctor, would focus on injury, on traumatic injuries, usually injuries to the skin, bruises and injuries to the skin. So I think in those visits to the hospital, there was a focus on the injuries to the skin, period.
So now, Dr. Andrew discussed a number of slides. Those, I believe, are called histological slides you testified to.
Microscopic slides or histological slides, same thing.
And I know we discussed it earlier, but once again, can you just tell the jury how are those slides made and what are they?
At the time of autopsies, a little piece of tissue about the size of a nickel is taken from each of the organs and put into formaldehyde and given over to the histologist, who can then make them into very thin slices that are put on a glass slide, and the doctor can then look at the tissue on light that comes up through the tissue. It's so thin that the light comes up through the tissue, and it's magnified hundreds of times, so that he or she can look at the microscopic appearance of the tissue with more enlargement than with the naked eye.
And are they helpful in figuring reasons and things out in the process of the human body?
Yes.
Now, Dr. Andrew testified here about slides once. And by the way, did you look through all those slides?
Yes.
The same slides that Dr. Andrew received?
Yes.
He indicated that on slides 172 to 178, there was an indication
Judge,
of...
we're going to object to leading, number one. I mean, this is his witness. Number two, he's not a rebuttal witness in regard to what Dr. Andrew said. It's not within the scope of his expert report. We are objecting at this time.
So the question is leading, but in terms of whether this physician agrees with Dr. Andrews, that's appropriate. So if you rephrase the question to a non-leading manner, you can continue.
Do you have an opinion as to why we see bleeding in the backbone that could be suggestive to a contusion in the lung?
Say that again.
Do you have an opinion of why we see bleeding in the backbone?
In the backbone, in the spine.
Yes. On the slides?
When an autopsy is done, the body itself contains all the blood that it has during life, filling up every blood vessel in the body, arteries, veins, and the capillaries. So when we cut into tissue, there's an automatic flowing of blood from the cut blood vessels, usually the capillaries. So it's common to have blood, a small amount of free blood on the backbone, in the pelvis, during an autopsy that's created by the autopsy incisions. It's like a garden hose. When the heart stops, it's like the outflow of water is stopped in a garden hose. But if you cut the garden hose, there'll be a leakage of whatever water remained in it. And that's what happens when we do an autopsy. There's no pumping of blood, but whatever blood is in blood vessels that are cut during the autopsy will bleed. It's usually a very small amount of blood.
And that is just whatever blood is left in whatever vehicle is used to transport it. That is whatever blood is left in whatever vehicle, like blood travels through what?
That whatever the blood attaches to by gravity, the blood will flow by gravity and going around the backbone or the back parts of the pelvis is normal.
So when you see blood in the pelvis, you would expect to see that in an autopsy?
Yes, a small amount.
Does blood evaporate when somebody dies?
Does
blood evaporate when somebody dies?
Not during the autopsy. No, it doesn't evaporate. It stays where it is until there's an incision made into the skin that will cause some leakage of blood from the cut blood vessels.
Now, a number of doctors testified here about numerous injuries to Corey's body. We had a bruise to his chest, a bruise under his chin, an abrasion to his hip, some light bruising on his back. Did you see those injuries?
Yes.
In your opinion, did any of these injuries have anything to do with Corey's death?
They did not.
Dr. Andrew discussed something called stress cardiomyopathy. Do you know what stress cardiomyopathy is?
It's a change in heart appearance on X-ray in somebody who has a severe emotional disturbance. It's called broken heart syndrome. The original name for it is Takotsubo's myocardopathy. Was described in Japan. We see in the United States. It occurred. 90% occur in women over 60. It's whatever it occurs. It's in elderly people who had severe trauma. The nature of the trauma causes a different shape of the heart on X-ray. That's where the Japanese term takotsubi comes from. It's sort of a squid shape. If there's no damage to the heart muscle is not damaged, and it will disappear, the change will disappear in about 2 weeks. So it causes no damage. It is a real change in the heart, but it doesn't cause damage to the heart. And as far as I could find, it's never been identified in 6-year-olds. It's in elderly people.
In your opinion, did Corey have cardiomyopathy?
He did not have. No, he didn't have any kind of cardiomyopathy before CPR.
So now, Dr. Andrews opined that Corey originally sustained these life-threatening injuries approximately 12 hours before his death. And then he changed his opinion based on 2 things. One was a 30...
Objection, Judge. He's leading and he's summarizing the witness's testimony. This is his witness during direct examination.
So the doctor didn't say change his opinion. He said that he excluded the time period because of the video.
Yes.
So if you rephrase the question, that he...
Thank you.
In terms of asking an opinion question, you're permitted to summarize the other doctor's findings.
Do you hear what the judge just said?
Yes, I did.
Okay. And he based that upon a 33-second video where Corey is speaking to his, I believe, his mother. Did you review that video?
I did.
Do you know how many words? By the way, did you see Corey on that video?
Yes.
You did?
The video I'm talking about, yes, I saw it.
You heard Corey or you saw
No,
it?
I saw it.
On the 33-second video?
I believe so.
The video which is audio of Corey.
Where he says, where's it, sound?
Yes.
Yeah, I saw that. I
Okay.
listened to it.
Okay. When you listen to that video, he also based his opinion on a photograph that was taken with Corey. First of all, does that video, to you, as a doctor, a forensic pathologist, former medical examiner, does that video have any diagnostic value in forming an opinion as to the cause of death of Corey?
Not to me.
Does that photograph that was taken at 2:02 of Corey asleep on his father's lap with his father smiling, did that have any diagnostic value with respect to Corey's death?
No.
Are you able to make a medical diagnosis based upon a picture of a sleeping child?
Not in this situation.
Are you able to make a medical diagnosis on a 33-second video where a child says less than 9 words?
I can't. Okay.
Okay. So, let me show you, it's been marked as States number 98. This is a picture of Corey's ear. I forget which ear it is. One of his ears. Have you seen that before?
Yes.
Okay. Now, it was Dr. Andrews' opinion that that was sign of an injury, and he was concerned because the ear is a covered portion of the body. Is your opinion that that is an injury to the ear?
No.
Can you tell the jury what that is?
Yes. That's the normal lividity, the normal settling of blood that occurs after the heart stops pumping. It's like if you give blood in a blood mobile, you very quickly see separation out of the red blood cells settling to the bottom. That's what happens with our blood, the blood in our body, when the heart stops pumping. The red blood cells settle by gravity to the lowest portion, and that's called technically LIVOR, L-I-V-O-R, mortis, liver mortis or lividity, and that happens to everybody after we pass away, because what the heart does, it not only pumps blood, but it mixes up the blood so that it's always looking red, but it has particulate matter, white cells, red cells, and platelets that are mixed up, and the heart distributes everything in a mixing fashion. But when the heart stops, all the cells drop to the bottom, forming this bluish type of appearance in the skin. This is on the right ear, and there's no evidence of any type of injury, in my opinion. It's just the normal settling of blood because he's lying on his back. 12 o'clock is where his face would be, and this is the bottom part of his ears that are beginning to show the blue lividity of of normal gravitational settling of blood when the heart stops beating.
Thank you, Doctor. Now, we started this with going from Ivy to Community Health to Jersey Shore, and now at Southern Ocean, you're saying he has pneumonia. Is it possible to develop that type of pneumonia within 12 hours?
It is. Staph aureus pneumonia can happen very quickly. Usually not, but it can happen quickly. And my opinion is based on the fact that there's something infection going on in Corey's body, and with all the findings, it's most likely, it's more likely than other kinds of infections being infection of the lung. It could be something other. There are other natural deaths that can occur in which the cause of death is not identified.
Would a pediatrician at Ivy Pediatrics who's doing a child abuse surgery assessment, child abuse assessment, be looking for infection?
Well, to some degree,
Judge, we're going to object to the phrase of that question. That was not the testimony that she was doing. It was that he was taken to the pediatrician for an examination. So that's, thank you.
So when he was taken to the pediatrician for an examination, were they looking for infection?
They would be looking for anything that was abnormal, but they were focusing on bruises on the skin.
Thank you, Doctor. By the way, do children decompensate quicker than adults?
It depends on what the situation is. It's very individual and what's happening.
How about this situation?
Sure, a Staph aureus pneumonia in a child could proceed very rapidly, yes.
No. Why do we do autopsies?
Well, one of the reasons we do autopsies is because it's the gold standard of what the cause of death is and what the abnormalities are. If the clinical doctor doing the treatment was right all the time, then there's no need for an autopsy. But autopsies are able to identify things and conditions that are missed or not able to be identified during the life of a person.
Can you give me 1 second, Ron?
Certainly. I'm sorry? Sure. Ladies and gentlemen, I apologize for the lengthy sidebar. Appreciate your patience. We were discussing a couple different things. Mr. Glucci, anything further from the doctor?
No, Your Honor.
All right. Thank you.
Thank you.
How's the state want to proceed?
Your Honor, do you want to proceed to the lunch break now or for another 5 minutes? I would defer to the court.
I would think we're not going to get much air conditioning relief over lunch, but I'm going to work on it. So now is as good a time as any to take a lunch break. Again, please don't form any opinions. Please don't discuss the case amongst yourselves. Don't research anything or look anything up. Please report back to jury assembly at 1:30. And doctor, please don't discuss your testimony during the break.
Thank you, Your Honor.
Thank you so much.
So you're by me. That's what I heard. Here's the date. Oh, yeah, that's something happening. Sorry. Watch the cord on your way out.
All right, 12:24 p.m. The jury's out of the courtroom. Anything from counsel?
No, Judge, thank you.
All right, see everybody at 1:30. Don't make the one come out last. Like, I feel bad with that with you.
Not when they're out.
Give me a seat here, folks. Thank you.
I think they wanted to come out.
I'm sure. Perfect. Jury up. 1:45 p.m. Thank you, everyone. Please be seated. So I've been working on the temperature issue. It doesn't feel any better in here, but I'm told that an HVAC contractor is on site. Hopefully they'll bring us some relief. So, or at least prevent this from happening again tomorrow. So I'll keep you updated. We're going to continue now with the cross-examination.
Thank you.
Ms. Lento.
Thank you, Judge. Good afternoon, Doctor.
Good afternoon, Ms. Lento.
So, Doctor, you're a forensic pathologist, correct?
Yes,
And you are not a board-certified pediatrician, correct?
yes, that's correct.
And you are not a board-certified infectious pediatric disease doctor, correct?
Yes,
And you prepared a report in this matter, right?
yes,
And you prepared this report on December 4th of 2023, correct?
check. Yes,
Do you have a copy of your report?
I do,
Doctor?
right here.
If I may approach, I actually have a marked copy for purposes of the record. If I may
Certainly.
approach, I have what's been marked S168.
Certainly.
Thank you.
You're welcome. And Doctor, you would agree with me that the purpose of your report is to document your opinions and to document significant facts as to what you relied upon in formulating your expert opinion, correct?
That's included in my opinion, yes.
And you reviewed various materials in this case, right?
Yes,
And per your report, you reviewed the Ocean County Prosecutor's Office report, right?
yes,
Did you review Detective Bromley's report from the prosecutor's office?
I don't recall whether I did or not.
Did you review the other 11 supplemental reports from the prosecutor's office relating to this case?
I have the report I relied upon. I don't remember the names of people.
My question was, Doctor, is besides the one report that you talk about in your report, did you review the other 11 supplemental reports relating to this case?
The report I looked at is rather thick. I don't know what's included in the distinctions you're making. I have it right here.
So besides the report that you reviewed, did you review any additional reports besides the one that you reviewed?
If they were not included in the report I looked at, I did not review them.
Okay, so you only reviewed the one report from the prosecutor's office, correct?
With multiple parts to it, but yes.
And you didn't review any of the police reports from the Alcoa, Tennessee Police Department, correct?
From the which one?
The Alcoa Tennessee Police Department?
I don't believe so.
Okay. And you didn't review the reports from the Ocean County Sheriff's Officer's Crime Scene Investigation Unit, right?
I believe that's true.
Okay. And as a forensic pathologist doctor and someone who has performed numerous autopsies, the facts surrounding a death or the attendant circumstances surrounding a death should be considered in determining the cause and manner of death, correct?
Yes.
And you have been published before, and you have said yourself that the manner of death is riddled with details, correct?
The manner of death is riddled. I don't think
Did
I
you
used
say
the
that,
term
Doctor?
riddled.
Riddled with details. Aren't those your words, doctor?
Not that I recall, but the manner of death includes many different types of information.
Okay. And in this particular case, doctor, are you aware that when Corey went to school on March 22nd, he had a bruise on his forehead and was sent to the school nurse?
I believe so. That sounds familiar.
And you did not consider that in your opinion or include that detail in your report, correct?
I didn't consider that it had any relationship to the cause of death.
And you also didn't put that fact within the report that you prepared, correct?
I may not have, right?
So, doctor, are you aware that Corey's first grade teacher saw him the next day on Tuesday the 23rd, and she saw a bruise and was concerned?
I don't recall that.
And are you aware that on Sunday, March 21st, Corey's grandparents, Carolyn and David Gregor, saw a bruise on Corey's forehead, and there was a family discussion about this bruise?
I remember there was a discussion in general about a bruise on his forehead, but I don't recall the details that you're referring to.
And you did not put that detail in your report, correct, doctor?
That's correct.
And are you aware that Corey's mother saw an imprint bruise and scrape on his chest when she was with Corey on March 23rd of 2021, where Corey was scared and upset, correct?
I remember there was a large bruise on his chest, yes.
And again, you didn't include that detail in your report, right, doctor?
That's part of the bruises I looked at, and that was a legitimate bruise and happened many days before he died.
Do you know that on March 25th of 2021, the defendant conducted a search on his phone as to will red marks turn into bruises?
No.
You weren't aware of that, doctor?
No.
And were you aware that on Friday, March 26th, Corey was kept out of school with an unverified absence?
I
You didn't
don't.
know that, doctor?
Probably not. I don't recall that.
Oh. And are you aware that on Sunday, March 28th, Corey's mother observed a large bruise on his chest and fingerprint bruises?
And I'm sorry, and what?
Fingerprint bruises, as she described in her testimony?
I don't know what fingerprint bruises are, but I do recall the large bruise on his chest, yes.
Okay, and you didn't include that detail in your report, right, doctor?
That is, I had that considered, and I didn't go over every bruise, but because I recognized them and I referred to them, but I didn't think they had anything to do with his cause of death.
Okay. And are you aware that on March 28th, officers from the Barnegat Township Police Department also saw this bruising on Corey?
Not specifically, but others had. I understand.
Are you aware that Corey's teacher saw bruises on Corey on Monday, March 29th, 2021, while Corey was attending virtual school on the computer?
I don't recall that.
Okay. Are you aware that Corey's teacher saw bruising on March 30th of 2021 while she was instructing Corey virtually on the computer?
I don't recall that.
Are you aware that Corey's teacher saw marks on Corey's face when she saw Corey virtually for school on March 31st of 2021?
I don't recall.
So, doctor, you didn't consider that Corey's teacher, the person who would be with him every single day, was concerned about bruising and saw this on Corey's body in formulating your opinion as to cause and or manner of death?
My opinion as to cause and manner of death were dependent on the findings at the time of death, and that whatever injuries and bruises which I looked at and which Dr. Regassa described did not cause or contribute to his death. That was my opinion after looking at the various bruises, and I agree with Dr. Regassa that it had nothing to do with his death.
Okay, so you reviewed medical records from IV Pediatrics?
Yes, at some
And
point.
you noted in your report that Corey's mother brought him first to IV Pediatrics, then to Community Medical Center, and then to Jersey Shore University Hospital, correct?
Yes,
And according to the medical reports, Dr. Deacon, Corey's pediatrician, examined Corey at approximately 5:15 on April 1st.
that sounds right.
And Corey told the doctor that he had bruises from playing football and when he fell, correct?
Yes,
And during this pediatrician's visit, Corey had no fever, correct?
there was no fever mentioned in the report.
And Corey's throat was not red, right?
That is my understanding, yes.
His lungs were noted to be clear, right?
Yes,
His lymph nodes were not enlarged, correct?
yes,
And his breathing was normal and quiet, correct?
I believe so at that time.
And he had full breaths, right?
I'm sorry, he had,
Corey had full breaths was the description, correct?
yes,
And Corey's lungs were noted to be clear, right?
yes,
And Corey's spleen was not enlarged, right?
that's correct.
And his liver was not enlarged, correct?
That's correct.
And the pediatrician noted 14 areas of bruising and or contusions located on Corey's body, right?
Yes,
The pediatrician then sent Corey and his mother to the hospital for blood work, right?
yes,
And Corey was examined by the pediatrician approximately 24 hours before he was pronounced, correct?
yes,
And that would have been less than 24 hours from when Corey was brought into Southern Ocean Medical Center in Stafford, right?
yes,
And Corey was examined at Community Medical Center, correct?
yes,
And that examination, there were no significant findings noted, correct?
as I recall, yes,
And you also reviewed medical records from Jersey Shore Hospital, right, doctor?
yes,
And Corey arrived at Jersey Shore Emergency Room at approximately 8:34 p.m., right?
yes,
And Corey arrived at the hospital with his mother, right?
yes,
And the chief complaint when Corey went to Jersey Shore was bruising, correct?
that's true, yeah, the evaluation of the bruising.
Right. And when Corey was being evaluated at the emergency room, he appeared scared and was afraid to answer the doctor's questions, correct?
I don't recall that specifically, but it sounds right.
Okay. And at Jersey Shore, a head-to-toe examination was conducted of Corey by the treating doctor, correct?
Yes,
And during the physical examination of Corey, Corey's lungs were noted to be clear.
yes,
Corey was not wheezing at Jersey Shore.
that's correct.
Corey was not in respiratory distress while at Jersey Shore.
That's correct.
No fast breathing was noted while Corey was at Jersey Shore.
That's correct.
And no hypoxia was noted while Corey was at Jersey Shore, right?
That's correct.
And there were approximately 12 different bruises or lacerations noted on Corey's body in various different stages of healing, documented by the doctor at Jersey Shore, right?
I don't recall the lacerations, but the bruises were enumerated, yes.
Did you review the medical records from Jersey Shore, doctor?
I believe so.
And if I showed you the medical records, would then you agree that there were also lacerations that were noted as well?
Were they noted? Does it say where they were noted?
Yes, they were, doctor. Did you review the body chart that the emergency room doctor basically drew into the chart records?
Yes, but I'm basing my opinions on what was seen at the time of the autopsy. There were no lacerations at the time of the autopsy, and many of the listed bruises weren't there. They weren't there to the naked eye, and they weren't there when they were examined under the microscope.
I understand that, doctor, and I respect that, but my question was about Jersey Shore, specifically as
Right.
that night, and whether or not
Yeah,
there was lacerations noted in the chart.
Okay, I don't recall the mention of lacerations, but that could have well been stated.
Now, at approximately 10:49 on the evening of April 1st, blood work was collected from Corey so panels could be run while he was at Jersey Shore, correct?
Could you repeat that, please?
At approximately 10:49 on the evening of April 1st, blood was collected from Corey so panels could be run regarding his blood work.
Yes.
And so this would have been approximately 17 hours before Corey was admitted to Southern Ocean Hospital on April 2nd, correct?
Right.
And Corey's white blood cell count was within normal limits about 17 hours before he presented at the hospital the next day, correct?
Yes.
And at 11:01 p.m., a skeletal bone survey was conducted at Jersey Shore, right?
Yes.
And as part of the survey, a chest x-ray was performed, right?
Yes.
And the condition of Corey's lungs were noted to be clear, with no infiltration, with no significant findings, correct?
Yes.
And Corey was not admitted as a patient at Jersey Shore, right?
That's correct.
And Corey did not actually see the staff pediatric child abuse specialist while at Jersey Shore the evening of the 1st, right?
I don't recall that.
And were you aware, doctor, that that weekend was Easter weekend?
Yes.
Now, Corey was discharged from the hospital after 1 a.m. the morning of April 2nd, 2021, right?
Yes.
And Corey was examined 3 separate times while at Jersey Shore with no significant findings, right?
Right.
And Corey was at Jersey Shore Medical Center. He did not have a fever, correct?
That's correct.
And while Corey was at Jersey Shore Medical Center, he was negative for COVID, right?
Yes.
And he was also negative for the RSV virus, right?
Yes.
And he was also negative for the flu A, correct?
I believe so.
And he was also negative for the flu B, right?
Yes.
Now, on April 2nd, per your report, Corey was returned to his father about 9 a.m. that day, right?
Yes.
And are you aware that the defendant sent a text at approximately 9:05 a.m. to a female that he had met online named Marcy, stating that Corey was fine when he came home?
I don't recall that.
And are you aware that at 9:49 a.m. that morning, the defendant sent a text to Corey's mother stating that she was going to be in for a rude awakening, not indicating that Corey was sick at all?
I don't recall reading any text messages.
Are you aware that at 9:55 a.m., the defendant sent a message to a female named Amy confirming that Corey was okay when he was brought home that morning?
I didn't see any text messages.
So you didn't review the text messages in association of this case?
That's correct.
Okay. Doctor, are you aware that at 10:04 a.m., the defendant called the child abuse hotline regarding concerns for Corey, but didn't say that Corey was sick or that anything was wrong with Corey?
I don't recall one. I don't recall.
Doctor, did you review the transcript or the copy of the phone call where the defendant called a screening officer at 10:04 a.m. the morning of April 2nd?
No.
Are you aware that during this phone call, doctor, that that the screener asked the defendant if anybody had or is having a series of respiratory infections, coughs, sore throats, anything like that, and the defendant said no?
No,
You're not aware of that, doctor?
I'm not aware.
Do you know that at 2:13 p.m. on April 2nd, less than 3 hours before Corey passed, the defendant asked Marcy to talk on the phone?
The defendant asked who?
Asked Marcy, the girl who he had met online, to talk on the telephone.
No,
Are you aware at 3:22, about 25 minutes before Corey presented at the emergency room at SOS, the defendant sent a message to Marcy, "I'm so excited, ha ha."
no,
Okay. Do you know that at approximately 3:08 p.m. on April 2nd, the defendant conducted a search on his phone for lost consciousness, sleepy, and nauseous?
no,
And did you know, doctor, that the defendant deleted this search from his cellular phone?
no,
And were you aware that the defendant deleted his text messages between himself and Corey's mother for days around the time when Corey had passed?
no,
Are you aware that at approximately 3:30 on the 2nd, the defendant spoke to Corey's mom on the telephone and told her that he was bringing Corey to the hospital, but didn't tell her what hospital he was actually taking Corey to?
I don't recall that.
Doctor, did you review the surveillance videos from Southern Ocean Hospital?
Did I review the?
Surveillance videos from Southern Ocean Hospital?
No,
Okay, doctor, you didn't review multiple different surveillance videos from Southern Ocean Hospital where the defendant is seen taking Corey to the emergency room and taking him from the back seat of his car. You didn't see that video?
no,
Did you see the video when Corey presented at Southern Ocean Medical Center where you can see the condition that Corey was in when he actually presented to the hospital?
I don't believe so.
And did you see the video where the defendant is seen leaving the ambulance entrance of the hospital?
No,
Now, you said, doctor, that you reviewed the medical records from Southern Ocean Medical Center, right?
yes,
And Corey arrived at the hospital and he was taken into room 6 in the emergency room, right?
yes,
And when Corey was taken into room 6, at that point, blood was drawn from Nurse Doyle about an hour before Corey was pronounced, approximately, correct?
I'm not sure of the timing, but sounds right.
Okay. And are you aware that when the defendant provided a case history as to what was going on with Corey, the defendant was described as clinical in his demeanor?
No,
Are you aware that while at the hospital, less than an hour before Corey's death, the defendant told medical staff not to contact Corey's mother?
no,
Corey was intubated at the hospital, right, doctor?
yes,
Now, doctor, are you aware that the CPR that was performed on Corey has been described before the jury as pediatric CPR?
sure,
And are you aware that the nurse who actually supervised the CPR had testified that one-hand CPR, pediatric CPR, was performed on Corey because he was 6 years old?
I don't remember the details, but sounds right.
Now, doctor, those details, that's not anywhere in your report, correct?
No,
Now, doctor, are you aware that the defendant was noted to be at Corey's bedside at approximately 4:51 p.m. while at Southern Ocean Hospital?
Say that again?
Are you aware from the medical records from SOCH that the defendant was noted to be at Corey's bedside at approximately 4:51 p.m. that day on the 2nd?
Not specifically, no.
Are you aware that Corey was pronounced at approximately 5:03 that day?
Yes.
And are you aware that the defendant left the hospital about 17 or 18 minutes after Corey was pronounced?
No.
Did you review the surveillance video from the hospital where you can see this? As we
No.
talked about before, where he's leaving the ambulance entrance of the hospital?
No.
Are you aware, doctor, that while the defendant was at the hospital at approximately 4:40, he called Marcy, this girl he had met online, about 2 times, and this would have been 23 minutes before Corey was pronounced?
No.
Are you aware that the defendant did not answer calls from Corey's mother at 5 p.m. and 5:04 p.m.?
No.
Are you aware that defendant's father told his son that he was going to call the police, and when the defendant's father got to the hospital, the defendant had left?
No.
Are you aware that the defendant searched, can your phone be tracked in airplane mode at 6:10 that day, and then searched, can my car be tracked at 6:10?
No.
Are you aware that the defendant then put his phone in airplane mode at approximately 6:31 p.m.?
No.
Are you aware that the defendant didn't put his phone back on until approximately 2:19 the following day?
No.
Are you aware that when the defendant put his phone back on, he was in Arkansas by the Texas border?
No.
Are you aware that the defendant spoke to his father in a 25-minute phone call where his father told him to come back, and only then did he turn around and start heading east, doctor?
No.
Now, doctor, you talked about in your direct testimony this post-mortem CT scan, correct?
Post-mortem is, I'm sorry?
You talked about in your direct examination this post-mortem CT scan which was performed, correct?
That the post-mortem CT scan was a what?
Was performed on Corey, correct?
Yes.
Okay. And this scan was actually ordered by Dr. Larkin, right?
Yes.
And Dr. Larkin is not a medical examiner, but he is an investigator with the Ocean County Medical Examiner's Office, correct?
He's a physician investigator, yes.
Right. And he's not a forensic pathologist, correct?
No, he's a family practice doctor.
Right. And the post-mortem CT scan of Corey's lungs was taken about 3 hours after Corey passed, correct?
That sounds right.
And the scan was interpreted by a clinical radiologist who was working at the hospital, correct, doctor?
It was interpreted by a radiologist. I don't know the exact title, but it was interpreted by a radiologist who interprets CAT scans.
Right, and the scan was not interpreted by a forensic pathologist, right, doctor?
That's correct.
And it was not interpreted by a pediatric infectious disease doctor, correct?
That's correct.
Now, this lung swab that you were talking about before, this actually occurred during Corey's autopsy on April 3rd, correct?
Yes.
And the autopsy started at approximately 9 a.m., right?
Yes.
And this would have been the following day after Corey passed, right?
Yes.
And this lung swab, where the staff was noted, you are relying on to formulate your opinion, that was taken after Corey died, right?
Yes. I'm including that in my opinion as one of a number of things I'm relying upon, yes.
So while Corey was actually at the hospital, nurses touched his body, correct?
Yes.
And the doctor touched his body, right?
Which doctor?
The doctor who would have been at SOCH, let's say Dr. Pachotti touched his body, correct, doctor?
Yes.
Okay.
Yes.
And Corey's body was actually transferred by a funeral home to Community Medical Center where the autopsy was performed, right?
That's my understanding.
And now, doctor, while Corey was alive at the hospital in SOCH, blood was drawn, as we said before, about an hour before he died, correct?
Yes.
And there was a blood culture done regarding his blood, which was taken while he was alive at the hospital, right?
Yes.
And the blood culture came back that there was no bacteria found in Corey's blood while he was alive, correct?
That's correct.
And you don't mention that there was a negative blood culture for bacteria in your report at all, correct?
I'll have to review it, but if you say so, I agree with that.
You also indicate in your report that Corey was talking when he was at the hospital at SOCH, correct?
I believe so.
And are you aware that the nurse who treated Corey, who was actually there, said that Corey mumbled and then began to seize?
Was that before or after the intubation?
That would have been before the intubation. Are you aware that when Corey was at the hospital, the nurse who treated him described him not as talking, but mumbling, and then he began to seize?
That sounds right.
Now, doctor, you are being paid for your testimony in this case today and for your review of the materials, correct?
I'm paid for the time I spent, yes.
And before, during your direct examination, you testified about polycells, correct?
Yes.
And again, doctor, nothing about these polycells is listed in your report whatsoever, correct?
May not be. I say there was a high white blood count someplace, I believe. I'm sure of that.
But doctor, I believe your testimony was polycells specifically in regard to inflammation, correct?
Well, the high white blood count is consisting of the polymorphonuclear cells.
Right, so my question is though, regarding that, that's not specifically listed into your report.
I may have just included the white blood count being very high.
Now, doctor, before you came to court today, you watched Dr. Andrews' testimony, correct?
No, I think I received a transcript. I read it.
Okay, so you reviewed a transcript of Dr. Andrews' testimony
Yes.
before you came to court today.
Yes,
And you also reviewed a transcript of the infectious disease doctor's
Dr.
transcript as
Feingold,
well.
yes.
Okay. Now, doctor, you reviewed Dr. Vargas's post-mortem examination report, correct?
Okay, you see, I'm agreeing with you too much. I have a sentence here, 29,000 white blood cells with an increase in polymorphonuclear cells, an indicator of infection. I do mention that.
Okay. I was talking about the inflammation part, but that's okay, doctor. So again, you reviewed the post-mortem examination report authored by the Ocean County Medical Examiner's Office, correct?
Yes.
And the autopsy was performed by Dr. Ragasa, as we said, on April 3rd of 2021, right?
Yes.
And in this report, Dr. Ragasa concluded that there were multiple contusions with different stages of duration, correct?
Yes.
And he also concluded that there was an epicardial contusion with myocardial laceration with acute inflammatory reaction, correct?
Yes.
And Dr. Regassa had initially found that the manner of death was not determined, correct?
That's correct.
And then on August 18th of 2022, the manner of death was then changed to homicide, correct?
Yes. 14 months later, yes.
Right. And you also reviewed Dr. Andrews' report before you came to court today, right?
Yes.
Okay. And do you know when Dr. Andrews' report was prepared?
I don't. He had two reports, as I understand. One of them that I have here is February 25th, 2022. And there was another one that I don't have right here.
And actually, Doctor, there was actually 3 reports prepared by Dr. Andrew in regard to this matter. Is that correct?
I don't recall. I just recall 2 reports.
You only reviewed 2 of the 3 reports, Doctor?
I think so.
Okay. Doctor, nowhere in your report do you indicate that Corey's lungs had pus, correct?
That's correct.
And nowhere in your report do you indicate that Corey's lungs had an abscess, correct?
That's correct.
So, Doctor, just so I understand, you have concluded that Corey had pneumonia and sepsis, and you based this upon a postmortem CT scan interpreted by a clinical radiologist, a lung culture taken the day after Corey died, while a blood culture existed showing that there was no bacteria in Corey's blood, correct?
And what I saw under microscopic slides. And the blood culture has little significance.
A blood
Because
culture has little
95% of the
significance.
time they turn up negative, even in full-blown pneumonia.
Okay, Doctor, it's also your opinion that Corey died from non-symptomatic hyperspeed pneumonia while he was also presenting with bruising, correct? Symptomatic hyperspeed pneumonia while he was also presenting with bruising, correct?
That's my best opinion based on the information available. That's right, that the bruising had nothing to do with the death,
Right.
and that he had symptoms of bronchopneumonia, and X-ray and autopsy findings of that, but that it's not my definite conclusion. It's that that's the most 55-60%. It's more likely than not the most likely cause of his death, even though there are other natural conditions that could also have been missed at autopsy.
So, Doctor, you're not with absolute certainty that that's the way that Corey died?
I'm absolute 100%.
You're not absolutely
Objection,
certain
Judge.
that's the way?
He's answering the question.
Well, I thought he answered it with a request for clarification. So go ahead, Ms. Langton.
Thank you. So you're not absolutely certain that that's how Corey died because, as you just said, there could have been other possibilities, correct?
You're confusing what I'm saying. I'm absolutely certain that he didn't die of cardiac trauma, as was Dr. Regassa when he did the autopsy. Put down after the heart disease question CPR right on the first day that he looked at those injuries. So I'm certain he did, and from the fact that you can't live more than a couple of minutes with that kind of injury, I'm certain he didn't die of heart and liver and lung injury. I think the most likely cause of death is some kind of pneumonia that developed that evening after he went to a number of hospitals where he could have picked up that bacteria. But that's the most likely, but I'm not saying it's definite.
Okay, Doctor, I appreciate that. And you also said during your direct examination that Corey could have died from sudden, unexpected 6-year-old death syndrome?
Yes, sudden, unexpected, sudden, unexplained death in childhood, which is a cause of death that is listed hundreds of times every year in children who die like Corey, where the cause of death isn't certain.
Okay, so the cause of death is not certain, and are you aware, Doctor, that Corey was almost 7 years old when he passed?
Yes, I am.
Thank you, doctor. No further questions.
Thank you. Mr. Palucci, any redirect?
You did agree with her a lot, right?
Well, she is a very good attorney.
Right? And you agreed with her.
I'll take it.
And you agreed with her because what she was asking you was true, right?
That's correct.
So you did not review what his teacher, Kim Peace, noted when he was in school at the time, did you?
I did not review that.
Okay. And by the way, had you reviewed that Kim Peace, when he was in school on one day, saw a bruise to him, would that affect your opinion as you sit here right now and you testify about how Corey died?
It would not have changed my opinion as to the cause or manner of death, which is most apparent from the different reasons I gave.
Does Christopher's internet searches have anything to do with a forensic pathologist's diagnosis as to cause and manner of death?
No.
Does Christopher's conversations with two separate females have anything to do with the forensic pathologist's cause or manner of death?
No.
What is a radiologist?
A radiologist, the 24 specialties in medicine, OBGYN, pathology, internal medicine. Radiologist is a specialty in which x-rays are used to determine abnormalities in the body, and they have expanded greatly with CAT scans and modern x-rays to be involved with placement of different kinds of devices in the body. So they're a very active specialty in medicine.
So a radiologist, is that a doctor?
Yes.
Does a radiologist go through special training?
Yes.
Does a radiologist do the stuff that you had to do to get to where you are, except instead of him becoming a forensic pathologist, he decided, or she decided he was going to be a radiologist?
Yeah, and there are certain requirements in all 24 specialties about being board certified in that specialty, which are similar, and in their different specialties. And a radiologist goes through the same length of training as a pathologist, but studying different avenues of bodily abnormalities.
But just to be specific here, a radiologist is not the one that puts you into the machine and goes click, click. Am I right?
Well, that's part of what happens. The radiologist that, puts it to the machine and decides what kind of x-rays to take and interprets those x-rays.
And do they go to school to learn how to interpret those x-rays?
Yes.
And they go to medical school to learn how to interpret those
yes.
x-rays? And do they take internships and residencies and do all those other things to determine what an x-ray shows and what an x-ray doesn't show?
Yes.
Have you, in your years of practice, ever seen anybody grieve?
Grieve?
Grieve.
Yes.
Objection,
Yes.
Judge. I don't understand the relevancy of the question.
It goes right to, you want a sidebar?
No, it's overruled.
Thank you, Judge. In all your years of practice, do all people grieve the same way?
No, absolutely not. People grieve in totally different ways and react to the death of a loved one in different ways. And there's no just one way that people are upset. Absolutely not.
Now, did the fact that Christopher left the hospital and drove to Arkansas and came back have anything at all to do with your diagnosis as to cause and manner of death?
No.
Would his text messages have anything to do with your diagnosis as to cause and manner of death?
No.
Ms. Lento, these blood cultures, brings up blood cultures. We've heard a lot about blood cultures from a number of experts. Once again, can you tell the jury the significance of a blood culture?
Judge, we're going to object. This has been asked and answered 5 times already.
I mean, it was explored on both direct and cross. It can be explored on redirect a little bit.
Thank you, Judge.
Yeah. Blood culture is taken to try and find if there are any bacteria growing in the bloodstream. In a person with an infection, such as pneumonia, sometimes bacteria are found, and this doesn't determine the cause of the infection. Pneumonia is based on different things, but it would determine the bacteria and the susceptibility of the bacteria to various antibiotics that might be given. So it can be valuable, but studies have shown that in 95% of the time, even in somebody with a pneumonia, it doesn't pick up bacteria unless it's done repeatedly over a period of time, and then it'll pick up maybe 10 or 20%. But not a single blood culture negative does not rule out presence of a pneumonia.
Ms. Lento, on her cross-examination, brought up the fact that when he was at the hospital at Southern Ocean Medical Center, that he was touched by doctors, that he was then touched by doctors at Jersey Shore Medical Center, that he was touched by a funeral parlor person who brought him to whatever place they did the autopsy, that he was probably touched by a number of people during this. Does that have anything whatsoever to do with your diagnosis as to cause and manner of death?
No.
Is it of any significance whatsoever to this case?
Well, it may have significance, but it has no significance to the cause and manner of death.
Would a child sleeping all day be an indication that they are ill?
Not necessarily.
One second, Your Honor. Ms. Lento mentioned a number of bruises that were documented at Ivy Pediatrics, that were documented at Community Health, that were documented at Jersey Shore Medical Center. We know that there was a treadmill on March 20th of March 20th, 2019. We know that he had a football practice. We know that he went and visited Grandma and Grandpa. Did any of the bruising have anything whatsoever to do with Corey's death?
No.
Is there any additional bruising on Corey during the autopsy
No, the autopsy, in fact, Dr. Ragasa was careful to take microscopic sections of all of the indicated bruises and found that under the microscope there was no hemorrhage. You have to have a hemorrhage in a fresh bruise. That in more than half of them looked like bruises, but they weren't. And the bruises that were present were healing bruises from a time period before, not from the time of death or around the 24 hours before death, except for the bruises caused by CPR.
And that would be the damage to the heart,
Yes,
the damage to the liver.
yes.
Thank you, Doctor.
Thank you.
Any recourse?
No, Judge, thank you very much.
Doctor, thanks so much for coming in.
Thank you, Your Honor.
Take care, sir.
This is...
Counsel at sidebar, chance, when the report is ready.
I can take that.
Ladies and gentlemen, I think it's best if I send you back to jury assembly rather than try and go into the jury room because it's probably so uncomfortable. You need to determine what the status of any additional witnesses are and things like that. So it's going to probably take us a little while to do that. So if you go over there, just relax and we'll call for you as soon as we can. All right. If you need to take anything, that's fine. But either way, I'd have to bring you back here so you can also leave things in the jury room if you need to as well.
Questions?
Take your snacks, we have anything. Take it with you.
Just distinguish this. Okay. I got that. Thank you. Yes. Your Honor, the juror wanted to remind you on Friday about the wedding.
Thursday. Thursday, I think she said, yeah, May 30th. All right, it's 2:41 p.m. Jury's leaving the jury room. Leaving the courtroom.
Sorry.
We have a conference at sidebar, so the next step would be for the court to conduct a hearing outside the presence of the jury about the defendant's election to either remain silent or to testify. Mr. Gallucci's asked for a few minutes to speak to his client regarding that. So we'll take a recess while that happens, and then we'll come back and put that on the record and determine what time it is and where we go from there. Counsel also spoke about when summations would be in relation to any additional witnesses. I really don't want to give an answer on that right now until I know what the defendant's position is and how long that takes, and if he is going to testify. But I appreciate what both sides has indicated, so I'll make a ruling on that once we know how Mr. Gregor wants to proceed with testimony. Anything you'd like to add before we step off the record? All right. Thank you. I'll come back
Rise.
in a little bit.
Please step out.
Shannon, we had opened the door or no?
We did.
That's what happened to me before. That's what I'm-
3 p.m., we're back on the record. The jury is over in jury assembly. Mr. Gallucci, you have an opportunity to speak to your client about whether he would testify or not.
I have none.
Any objection if I have him sworn in for the purpose of me asking questions about that decision?
No, Your Honor.
Thank you. Mr. Gregor, would you please rise and raise your right hand? The court reporter will swear you in, sir.
Do you solemnly swear the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Gregor, are you under the influence of any alcohol, drugs, or medication?
No, Your Honor.
You understand you have a right to testify in this case in your own defense. Conversely, you also have a corresponding right to remain silent and not testify in this case. Do you understand both of those rights?
I understand.
Have you had a full and fair opportunity to meet with your attorney to go over that decision?
Yes.
If you elect not to testify and thereby exercise your constitutional right to remain silent, no one may comment to the jury on your decision not to testify. Not me, and especially not the prosecutor. Do you understand that?
I do, Your Honor.
If you decide not to testify, there is a charge I would give to the jury with your consent. That charge would be, quote, as you know, Christopher Gregor elected not to testify at trial. It is his constitutional right to remain silent. You must not consider for any purpose or in any manner in arriving at your verdict the fact that Christopher Gregor did not testify. That fact should not enter into your deliberations or your discussions in any manner at any time. Christopher Gregor is entitled to have the jury consider all evidence presented at trial. He is presumed innocent whether or not he chooses to testify. Do you understand that charge?
I do.
If you choose to testify, the state would be permitted to cross-examine you. In other words, you wouldn't be able to revoke your decision after you testified on direct and not be subject to cross-examination. Do you understand that?
Yes, Your Honor.
After having met with your attorney and discussed the matter, let me back up. I also previewed this with you last week as well to give you notice I was going to have this hearing with you. Is that right?
Yes.
And between then and today, have you had time to consider what decision you want to make?
I have.
And you understand this is a decision that's personal to you. You're certainly expected to consult with your attorneys, but ultimately the decision whether you elect your right to remain silent or elect your right to testify is your decision. Do you understand that?
Yes, Your Honor.
And have you reached a decision, Mr. Gregor?
I have.
And at this time, can you tell me what that is?
I will not testify, Your Honor.
Mr. Gallucci, are you satisfied that your client is making that decision knowingly and voluntarily?
Yes, Your Honor.
Mr. Gregor, do you feel forced or pressured by anyone to elect not to testify and to remain silent?
No.
You're making that decision of your own free will after you've had sufficient time to consult with your attorneys?
Yes.
Thank you. Anything you'd like to add, counsel?
Your Honor, I have, as is known, spent many days down here in Ocean County meeting with my client and prepping him to testify. He has been very truthful with me all along about his desire to or not to testify. We've gone through it at length. I prepared him last week, and then, as you know, I became ill. I was still in communication with his family, and his family was in communication with him during that time. So I believe that I've spent a significant amount of time with him, that he has considered all of the ramifications, the pluses, the minuses, whether to testify or not to testify, and I'm satisfied that he understands the ramifications or non-ramifications of the decision not to testify.
Thank you. And you're also satisfied that if he elected to testify, you had prepared him for the testimony and the cross-examination?
Not only was he prepared, but I was prepared to do direct examination, and I was also prepared to encounter a cross. Hold on, my co-counsel. Yes, Judge.
Thank you. Anything from the state on that issue?
No, Judge, thank you.
All right, so do you want me to bring the jury back? Or like this, let me back up. Is there already any other defense witnesses?
There are no other defense witnesses. There were 3 exhibits I want to enter into evidence before I rest, but...
All right.
Yeah.
Well, why don't we do that now then?
All right. I believe they are...
Judge, can we see and compare like we did with ours, what's already in, so I have it for my notes, please?
Yes, so the only defense exhibit I have in now is D10. That's a letter from Kim Peace to Mr. Gregor, which went into evidence on May 1, 2024 at 11:38 a.m. I have no other...
Judge, I have D16 going in.
Oh, I'm sorry, that's on another page, you're right. Problem is I don't really have a defense exhibit list, so...
Judge,
What's D16, Madam Clerk?
D16 was the Arkansas map
Right.
that went in through
Sergeant Coles.
Sergeant Coles. And today D17 went in
Sergeant Murphy's body-worn camera.
Sergeant Murphy's body worn
Right, so those three are in. You have additional exhibits you want to move in?
Yes, Judge. D5. Do you want me to speak to the first? D5 is the, if you remember, the state had put in a snippet of a conversation with Brianna, and I put in the rest of the conversation from D4. It was the conversation with, excuse me, I'm sorry. It was the Facebook Messenger conversation with Dustin Boardman.
All right, so D4 was text messages where Ms. Michelow testified, and D5 was the Facebook conversation. You're moving just 5?
4 and 5.
4 and 5. What's the state's position?
Mara, do you have the exhibit so we can see what it is, just because I don't remember?
Judge, I would just like to reserve on the exhibits until I can actually see them myself. I haven't had the chance to examine them, except
Right, I mean-
for both of us did the quick second before they were brought up.
That would be almost a month ago, pretty much, that they were
Yeah.
testified to, so if we could pull those out.
Yeah, we just want a chance to actually physically look at what the jury's going to see, so if we have to do that tomorrow, I don't have a problem with that.
Okay.
The physical exhibit, though, would be
That's fine.
preferable.
Okay. I'll
So-
All right, so
4 and 5.
we'll come back to that tomorrow morning?
Then we have D13, which was put in through the crime scene investigator.
Sergeant Scuddy.
Yep, there's a picture of Brianna Michelow's bedroom with a ladder with the hole in the ceiling.
Right, D11, 12, and 13 were photos of Ms. Mitchell's apartment that Sergeant Scuddy testified to.
Judge, I don't have any problem with putting all three of those in, if you wanted to do complete.
Weren't they the ones that were, didn't I say they were duplicative of the state's exhibits?
The two of them, 11 and 12, were duplicative, 13 was not.
All right.
That's why I was asking for 13 to go in.
Do you want to pull out 13, or do you have it? Or do you want to reserve that for tomorrow morning so the state can see it?
Reserve that- We can reserve that for tomorrow morning. I might have that there tomorrow. And Judge,
Go ahead.
I'm sorry, you were right, I didn't want to interrupt you. D8, which was the community medical center release form that was signed by Ms. Brianna Mitchell.
We're objecting to that one. This is a medical record.
State's objecting, that you said?
Yes, Judge. It's a medical record. I mean, we have all of the medical records. I think both of us used it back and forth for identification, but I don't think there was any foundation laid for it to go into evidence. But if he shows that, we can bring it, we can argue tomorrow as well.
All right. I mean, it was allegedly signed by Ms. Michelow. I think she testified to that, so it may come in as an admission of a party. If it needs to be redacted, there's some other things on there, but to the extent it was her admission, it may be substantively admissible. I've never seen it, though, however, no one's shared it with me, so.
Yeah, Judge, that's my point. Basically, he used it for impeachment purposes of her. It wasn't, it's the AMA from
Right.
community, so.
Right. All right, so we'll do all those things tomorrow morning when everyone reviews those exhibits?
Sure.
Any more, Mr. Galucci?
That's it, Judge.
All right, so are you comfortable with me telling the jury there's no more witnesses? No rebuttal witness from the state?
No, Judge.
All right, so then what do we want to do about, we need to have a charge conference, so can we stay to do that today, finish that up today, after we excuse the jury?
Sure.
And then, is there any reason we can't go to summations tomorrow?
Well, I would prefer to do Thursday. I've already made my reasons why.
Well, I appreciate the reasons why if your client wasn't testifying, but, you know, I'm going to release the jury now at 3-something and say don't come back again until Thursday, so I mean, why wouldn't overnight be sufficient to prepare for these things? I mean, I don't think I'm being unreasonable by asking you to sum up tomorrow. I'm hard-pressed to think of a full day we've ever had in this trial right now, so I appreciate you were sick over the weekend, but I mean, something we talked about, we knew coming. I don't think Dr. Bodden's testimony changed what you're going to sum up on other than some of the things he said, but it doesn't really change our jury charge. It's consistent with his report. There was no surprises, so everybody anticipated what that was going to be. So, I mean, if you want to put your reasons on the record again as to, but I mean, I appreciate that you were feeling ill over the weekend, but I don't know why tonight wouldn't be sufficient to be able to respond to that, because we have an issue on Thursday with one juror who's told us that she has to leave early for a wedding. So then if we delay this to Thursday, I don't want to be in your summation, the state summation, and my jury charge, and we have to stop in the middle of my charge because we have a juror that we promised she would leave. Or excuse her then prematurely after she's been here the whole time. So I prefer... why we tell them to come in 10 tomorrow and give you a little more time in the morning?
Perfect.
All right. Acceptable state?
Yes, Judge, thank you.
All right, so then before because we need to remove the part about, we need to keep the part in about the defendant's election not to testify, and then you wanted to address the state's case law on a potential lesser included on the second-degree endangering. You able to do that today?
Judge, I think that after Ms. Galante did her research on that, again, I hate to say it, but we agree with Ms. Lento, the state's decision.
Right, case law is pretty clear on that, so I appreciate that. We had talked about a couple of cases on that, but State versus N, period, A, period, 355, New Jersey Super 143, an appellate division case from 2002 makes clear that both charges are not lesser included. They're similar. There's no basis to acquit on a second degree and then convict on a fourth degree. It's a prosecutorial decision to pursue the second degree, and unless there's some gross abuse of discretion or arbitrary conduct by the state, there's no basis for the judge to have the fourth degree presented to the jury. Here there's no allegation and especially no evidence of any arbitrary action by the state, and I appreciate defense counsel confirming that, gave him an opportunity to be able to review that matter. So, and let me also just add too, with respect to Mr. Gregor, he's been in court with me now, obviously the whole trial, and for many months before that. I find he's alert and coherent. He's obviously not impaired or under the influence. He's represented by two very competent, experienced criminal defense attorneys. He's had a full and fair opportunity to meet with his attorneys. He's been aware all along that he had a constitutional right to either testify or, conversely, to exercise his right to remain silent. I find he's acting freely and voluntarily in choosing his right to remain silent, and that he's had sufficient opportunity to be prepared to testify on direct and cross if he had chose to testify today. And I accept that decision by the defendant as his own constitutional right to do so. All right, anything from the counsel before we bring the jury back over to excuse him for the day then?
Judge, I'm going to ask, but I'm going to ask if we could have a missing witness charge as to Dr. Wadowski.
Judge, the state's objecting to that. That's a procedure that's supposed to be done at the end of the state's case, where the state has the opportunity to then call the witness. And to be quite honest, that's a witness that's available to both parties. The defense could have called that witness as well. So under the case law, that's not permitted. And even further, the same procedure is supposed to be followed even if counsel wants to comment it on their summation and not even ask for the charge. That's State versus Carter, 91 New Jersey, 86. A 1982 case that's also cited in State versus Irving, 114 New Jersey, 427. A 1989 case, and of course to Flowens, which references the procedure in its entirety as well, and that's 38 New Jersey, 162, a 1962 case. So the time for that request has expired, and not only that, but the time to request the ability to argue it in closings has expired. And in addition to that, like I previously stated, counsel is also in a position where they could have called Dr. Ragassa. We went over ad nauseum Dr. Ragassa's vacation schedule so that either party could call him before he left for the Philippines. And now, quite honestly, it's too late. And that's why the requirement is the way that it is and should be timed the way that it's timed so nobody has the opportunity and gets boxed in that way. And that would be boxing the state in essentially by asking for the charge now after the close of the state's case when we no longer have the opportunity to call the doctor, and also when he's not here. And we went through, like I said, great lengths to make sure that didn't happen to the defense if they wanted to call him as a witness.
Anything you want to add, Mr. Glucci?
Judge, I have no obligation to do anything. Burden's always on them. I don't disagree with what Ms. Sharon has said about the fact that they made that schedule available to us, but being able to comment it on summation, I think, is fair game.
And Judge, I'm prepared with more case law and information if you need something written from me.
Well, first, with respect to whether the court would give a charge, that's known sometimes as an adverse inference charge or a Clowens charge under State versus Clowens, Clawans, 38 New Jersey, 162. That actually goes back to 1962. The case law requires that the party seeking the charge or comment must, before the opposing party rests, notify the trial judge and the opposing party outside the presence of the jury of the witness's name and indicate why that witness would have superior knowledge of the facts, and indicate that if the opposing party fails to call the witness, that at that point the proponent of the charge would seek an adverse inference. In this matter, we had specifically scheduled this trial to start and have jury selection in sufficient time in advance of Dr. Ragassa's departure. And in fact, that's half the reason why the trial was so unwieldy and we didn't always have witnesses available, because we started in April to be able to pick a jury. Dr. Ragassa was leaving the United States, I believe, on Sunday, May 12. On the record during the week of May 7, 8, or 9, I think it was the 8th, I even placed on the record as a reminder to everyone that if either side wanted to call Dr. Ragassa, that they should at that point, because he wouldn't be available after Friday, May 10th, because he was leaving on Sunday, May 12th. And I indicated that I would also allow the defense to call him out of order, and I could explain that to the jury, although obviously the defendant had no obligation to call any witnesses. At no time during any portion of that hearing or any other trial days was notice given to the state in advance of the state resting that defense would seek a adverse inference or Clowens charge. So the question becomes, therefore I find that it's inappropriate for the court to give a Clowens charge. Question becomes whether or not defense can comment about the absence of Dr. Ragassa as a witness. I mean, frankly, it's like the 800-pound elephant in the room. it's obvious that he did the autopsy. His name was probably mentioned more than any other person short of the defendant. All the experts were cross-examined on what Dr. Agasa did and found, even though he didn't come in. So, first, it's highly likely that the jury already appreciates that the physician who was the medical examiner and did the autopsy did not appear. Secondly, particularly within the control of the state, he works for the Ocean County Medical Examiner's Office. He frequently is called to testify. The jury's already heard evidence that he initially determined the cause of death was undetermined, and in August of 2022, he modified his conclusion that the manner of death was a homicide after the state had obtained a report from Dr. Andrew. Dr. Bottom was specifically cross-examined on that on August 18, 2022, Dr. Agasa changed his conclusion to a homicide, and that would be a little less than a year and a half after the child's death. There's nothing in this court's view to find that his testimony would be insignificant or simply cumulative or unimportant. In fact, in this court's view, it would have been important because he did many of the things firsthand that the other experts testified to. So therefore, much of what came in from the autopsy was hearsay, but experts are permitted to testify about hearsay in situations where they rely upon it. It's natural for an expert witness to rely upon hearsay in the course of their functioning. In fact, it's more likely that he would have had superior knowledge as to exactly what was conducted at the autopsy and his own findings. Here I conclude that it's not appropriate for the court to say that there's some inference that because Dr. Agasa was not called, that would be unfavorable to the state. But I find it's at least appropriate for either side to mention that he wasn't called as a witness, because that's already out. The jury already understands it. The jury's already aware of it. We've already heard that Dr. Larkin, who's a medical examiner investigator, went to the hospital and ordered the CT scan. We've heard from Sergeant Scuddy about the autopsy, but we never heard from the medical examiner. So under those circumstances, I find that it really makes little difference if the defense is able to reference the absence of Dr. Agasa as a witness. That being said, though, it would be inappropriate for either side to say in summations the things Dr. Agasa would have said or would not have said unless it's already in evidence by some other witness. So, for instance, you can't add to those things that if Dr. Agasa had testified, he would have said X, Y, and Z if that X, Y, and Z is not already in the testimony of Dr. Andrew or Dr. Baden or, I suppose, Dr. Feingold. But in this case, because it's already patently obvious to the jury that the medical examiner performed the autopsy, did not testify, there's nothing particularly inappropriate about allowing counsel for either side to mention that. The state may say, the state chose not to call him because he originally determined it was undetermined, and then Dr. Andrew was the first one to determine it was a homicide, so the state relied upon Dr. Andrew. Defense may argue that it's unusual not to call a medical examiner. Both of those things are, medical examiner did the autopsy, so both of those things are within the common sense of the jury to draw its conclusions. It also relates to the credibility of the witnesses the jury did hear, and to the extent they relied upon findings of the non-testifying medical examiner. So, in summary, the court will not give a missing witness charge or a Clowens charge. Counsel are permitted to comment that Dr. Agasa wasn't called, but not to add anything that was not otherwise in evidence. That should be obvious. Obviously, you can't say in a summation something that's not in evidence, but, for instance, you have the benefit of all the records that Dr. Agasa may have prepared. I do not, so I just, in an abundance of caution, of indicating that you can't add something that, even though it may have been evidential, if he was called to testify, it's not in evidence in this trial, and it can't be commented on. So in making this decision, the court also relies on State v. Hill, 199, New Jersey, 545. That's a 2009 case. And the Clowens case, obviously. All right, anything before, we're going to release the jury for the day. Let's get it back here and release them, and then we can talk about any additions or changes to the jury charge. All right, can we go to the jurors, please?
Your Honor, can I have them keep their phones rather than hand them in and then get them right back?
Yeah, any objection if we just put them in a box and give them the charge to be released for the day? All right, that's fine. Perfect. Thank you, Sergeant. Thank you.
On the building, Your Honor.
Great, thanks. Thank you. Please be seated, everyone. Ladies and gentlemen, there are no more witnesses. The state has rested previously. The defense has now rested as well. So we're going to excuse you for the night, and then we're going to come back tomorrow. I'd like to report about 10 o'clock, maybe 5 of 10 in the morning to jury assembly, as always. So even though you've heard all the witnesses, you still can't start to form any opinions in the case. You still can't start to deliberate. You can clearly talk to each other on the way in or out of the courtroom, but don't discuss the case. So tomorrow, you're going to hear from the defense summation first, and then the state. It goes in reverse order of the opening statements, and then you'll receive my instructions on the law. That'll probably take the better part of the day. So hopefully by the afternoon, depending on A, how hot it is in the jury room, and B, how long the summations and the jury charge take, I'll then instruct you on going about your deliberations. You'll also get the exhibits at that point that are in evidence. So everything, every piece of paper, every physical item is marked as an exhibit for identification, but not every exhibit is admitted into evidence. So you heard me say multiple times, S1 in evidence, D15 in evidence. Those things go into evidence, so those are the things you're going to be allowed to take in the jury room with you. We'll also get you supplies, pads and pens and things like that, and I'll give you some indication of how you lock up that evidence. There's a black cabinet, there's an evidence cabinet. The foreperson's going to get a key to the cabinet at the end of the day, lock it up, come back out in the record, tell me it's locked. So any notes you keep, you're going to get 2 copies of my jury charge in writing as well. You can make notes on there or highlight things on there, and that's all your business. We're not entitled to look at your notes, so that's why you lock them up at night. The room can still be cleaned, and then the next morning I give you back the key, and the foreperson would open the cabinet, so you'd be able to retrieve your notes and the evidence. As you know, Christopher Gregor elected not to testify at trial. It is his constitutional right to remain silent. You must not consider for any purpose or in any manner in arriving at your verdict the fact that Mr. Gregor did not testify. That fact should not enter into your deliberations or discussions in any manner at any time. Christopher Gregor is entitled to have the jury consider all evidence presented at trial. He is presumed innocent whether or not he chooses to testify. And I'll include that as well in my final charge to you tomorrow. Anything from counsel before we release the jury? All right, so ladies and gentlemen, thanks so much. We'll see you tomorrow morning about 10 o'clock.
If you have something in the jury room, you think you got some board something out?
Yeah, if you have any belongings in the jury room, please feel free to take those. Take your time, no rush. Good? All right. Please be seated. 3:39 p.m., the jury has left the courtroom for the day. It is already been marked as an exhibit as C14, the verdict sheet, and the final jury charge, as we discussed last week, C15. Again, no portion of any jury charge conference has occurred off the record. My recollection is we had left open the section on defendant's election not to testify, to see if he would testify or not. And Mr. Gregor, it's correct, you want that statement in there about your election not to testify, correct?
Yes.
All right, thank you. So my recollection was the only other issue was potential lesser included, which defense concedes is not supported by the case law. So then is there any objection to C15 as we marked it last week? 28 pages, it ends on the top of page 28. Anything further from the state as to C15?
Judge, we're just checking.
Okay. Last week, because there were some questions as to the experts being paid. There is a model charge on, it's an optional charge on compensation of experts. The charge reads, the expert witnesses who testified, of course, are paid for their work. Experts are paid for their special knowledge, skill, experience, or training. Some may be full-time employees who receive a regular salary for their work, and some may be outside experts consulted for this particular case who received a fixed or hourly rate. You may consider the compensation received by the expert witnesses as bearing on their credibility. You should understand, however, that there's nothing improper in any expert receiving reasonable compensation for his or her work or for his or her appearing in court. And then there's an optional part. If you find from the evidence that the amount of compensation received is unreasonable, or if you find from the evidence the expert was paid simply to reach a particular result, you may consider whether that affects the credibility, interest, or bias of the witness. And then it should conclude in all cases with the following. As always, you may give the opinion such weight as you deem it deserves, consistent with the general rules of determining credibility. I don't think there was any questions about the amount charged by any expert, whether it be hourly or otherwise. Obviously, Sergeant Coles is paid a salary by the prosecutor's office. The other experts were retained by counsel on either side. Anybody wish to have that charge?
So, I mean, the way I look at it is it's offsetting penalties. I mean, I did it to Dr. Feingold. I asked if she was paid, and then I believe in turn Ms. Lento asked if Dr. Bodden was paid. I mean, if Ms. Lento has no problem with us not putting it in, I don't have a problem. If she wants it in, we'll put it in. I don't have a problem either way.
I mean, it's a foregone conclusion they wouldn't have been here unless they were paid, so they certainly had
Judge,
the right to charge their time to review all those records and come here and testify.
Yeah, Judge, for the state, it's kind of like a common sense thing, so we're not
All right.
specifically requesting the
That's fine.
charge, right?
All right, any other issues with the jury charge then, C-15?
No.
Couldn't
This is
just look
fine
at
the way it
one
is.
thing here. I don't think there was any objection. Judge, it's fine.
All right. Anything from the state?
No, Your Honor, the charge is satisfactory.
All right, so C15 is in evidence as a court exhibit, and then after I read the charge, I'll ask counsel to come to sidebar at that point to see if you have any concerns or objections, or if I misread anything. We notice any typos, we can always change that, and then if everything goes well, we have C15A and B, which would be the two copies the jury would take in. We previously marked C14 as the verdict sheet. That was actually what was prepared by the state originally. We discussed that. I believe it was already acceptable. Anybody have anything you want to add about that?
No, thank you.
No, Your Honor, the only objection we resolved with the lesser.
Very good. C14 in evidence for the purpose of a court record. Anybody using PowerPoints?
I would say there's 10% chance.
And the state like using the PowerPoint?
Yes, Judge.
All right, so my practice on the states is that after you're done, probably take a recess, you have an opportunity at that point to see the PowerPoint first to make sure there's nothing objectionable about it, but you don't have the opportunity to see it before you give your summation. Obviously, if it's something that could be said because it's appropriate argument on the evidence, it typically can be in the PowerPoint. Do you plan to quote extensively from testimony, from the transcripts?
Judge, I don't think we have extensive quotes, but we do have a bunch of those text messages and whatnot, so we do have them all put into slides for the PowerPoint. So.
The purpose of my question, though, is
Yeah.
really if when you do that, the jury then tends to ask for the transcripts. So I think we all agree that in New Jersey state court we don't give transcripts to jurors, even though in this case you have been ordering daily copy of the transcripts, at least the transcripts of the witnesses.
Yeah, we do not have extensive, citing specifically what the witnesses said put up onto slides.
You agree with that? We're not going to give the jury transcripts if they ask for
Judge,
it?
I don't think any court will give a jury transcript.
Right.
Usually it's a readback. I assumed I would just bring my copy of the transcript, and if they ask for a readback, then the four of us will sit here
Sure.
and look through the transcripts. Fine.
Right. My understanding is readback and as well as a video or audio playback needs to be done in open court so that the jurors do not pick out some portion of it and overemphasize it. If they ask for a readback of a certain area, then we'll discuss what that would be if that comes up. And then in terms of any PowerPoint that Mr. Gallucci is going to use, I would give the state the same courtesy, not tonight, obviously, but a few minutes before we're about to start with your summation, the state would have an opportunity to look at it to make sure nothing was objectionable in it.
Yes, Judge.
All right. So if you could each bring a paper copy then, make that easier. If you can print out a paper copy of the PowerPoint so you can hand it to your adversary before summations.
Will do, Judge. Thank you.
Do you want a second TV? We talked about that, right?
Yeah, we do, Judge.
So I'd like everybody to be able to see the jurors. So let's get a message to IT that we want a second TV hooked up so that this way, if the TV is not visible to everybody, it can also be played on that. It should be played on both TVs simultaneously. But I'm thinking maybe putting it at the foot of the jury box.
That's what we were saying, Judge, maybe the TV over there, kind of in the
play
corner
in
by
both
the,
places.
yeah.
Right. This way it doesn't block anyone's view of the
Yeah.
jurors. All right, we should be able to get that set up. I had told the IT department that that was a very strong possibility for summations and that they should be ready for it. If you plan to play videos or post pictures, let's make sure everything's connected. And then if you want to talk amongst yourselves of which computer you use, but the idea that wires, it's hanging on a hook on the state's table, but it's designed to go to either side. So you should be able to switch off. It's supposed to work where it just becomes a second monitor. So whatever's playing on your laptop should be playing on the big screen TV, and I'll have IT try and set up a second TV so it's essentially playing on your monitor and the two big TVs.
Yes, Judge, we'll be prepared with our equipment for tomorrow for our closing.
Okay. All right. Anything else I'm not thinking of?
Nope.
All right. Anything else before recess for today?
No, no.
No, Judge, thank you.
So we'll probably have, it was crowded today, we had pretty much a packed courtroom, there weren't a lot of empty seats, so there's been an overflow room designated every day. I don't know what that number is for tomorrow, but we'll post a sign on the door. I anticipate, obviously, tomorrow, a lot of people come to summations. So, Mr. Gregor's family should be allowed in. Sergeant Dugan's aware of this, the officers are aware of this. Ms. Michelow and her immediate family would be allowed in. Other than that, it's basically a first come, first serve. But anybody who qualifies as victim status under the Victims' Rights Act and anyone who's immediate family of the defendant should be permitted in this courtroom. Otherwise, you'd essentially be watching from a Zoom connection in another courtroom if there's not sufficient space in this courtroom. All right, thanks so much, everyone. We'll see you tomorrow.
All right. Please exit.